Megan Fox.
And Megan Fox has the story.
Megan Fox.
Megan Fox.
Megan Fox writes at PJ Media.
Eat Tucker.
And that was your last.
Damn it, man. I cried for 2 days.
Megan, thank you very much for that.
So, I can explain the bed thing.
If you don't show up and vote, up your ass. I don't care if you're in the hospital. Crawl to the stake. Crawl there.
It's like Jesus going into the temple. He's like, I got a whip. Get out! Get out! The lovely and wonderful Megan Fox. Not that one.
Not that one. Not the weird one that drinks blood in his toe thumb.
Megan Fox.
Megan. And honestly, Megan, if you don't like it, I'm sorry.
She's the devil.
Megan Fox. Megan Fox.
I've been very nice to you, although I could probably maybe not be based on the way you have treated me, but I wouldn't do that.
You've never met a like me. You want to tangle? You want to go? Holy sh!
Too much cussing on this. I guess we didn't bleep it, so we got to turn it off. But it's
You pissed off the wrong woman.
oh my God, I have been assaulted when Megan Fox runs wild on you, brother.
She's the devil.
Not for publication.
The story.
I'm Megan Fox. Thank you. Cheers.
Is my microphone on? Oh, okay. Well, folks, yes, just like somebody in the chat just said, what's with this piece of hair? What's going on here? I think we're going to need the entire global population of ducks for what we're about to witness today. Welcome to the show. I'm Megan Fox, and I'm an investigative journalist and part-time waitress. And I am a law nerd. And I am following this trial with you. Today is day 24. And Dr. Sally Smith. We've all been waiting for Dr. Sally Smith to take the stand. And I'm really getting annoyed with this piece of hair. Like, no, like, go away. Go away. All right. See, if I put them on like the right way, it smushes my hair. And I worked hard on these curls and I don't want, okay, there, that's better. All right. Here's the thing. I'm very angry right now because I just saw the Proffer part that happened before she was released. And for one, if there are attorneys listening, I know Jeff is sleeping, so I can't ask him right now, but I really want to know why they would do a proffer like that without the jury in the room and then dismiss her. So none of those questions were allowed to be asked. None of that, none of what we just heard before the lunch break is allowed to be asked in front of the jury. I don't understand the purpose of it then. Does anybody know why the proffer where Anderson finally got to go after her and he elicited out of her is the entire problem with Child Protective Services. For the appeal. Oh God, they said it was for the appeals process. I don't understand why those questions couldn't be asked. I don't understand why the questions of, are you a prosecuting investigator or are you a real child abuse investigator? Because she left out all exculpatory information out of her report. I'm I don't understand. Simpin Ain't Easy says, I missed the duck part. Can you explain? Sure. If you happen to be a Monty Python fan, then you will know that when there was a hilarious Monty Python skit in The Holy Grail about witch trials and about how to find out if she's a witch, if how to discover if someone is a witch or not. And it requires a duck. I don't know if you know about this, but it requires weighing the witch and the duck. And if the witch and the duck weigh the same, well, then the witch is obviously made of wood because ducks float and so does wood. Your Honor, permission to bring in all the ducks. Can we have permission to bring in all the ducks? Because we're going to need them for this one. Now, I predicted that Sally Smith was going to wear her hair down for this inquisition, because all of what we've seen of her has been with this severe pulled back hair, and she looks very harsh. And I knew that the defense was going to have her wear her hair down to soften her and soften the look. Well, in my opinion, it did soften her a bit, but it also revealed that she has the witchiest hair of the bunch. It's down past her back with the scraggly ends, again with the scraggly ends that nobody trims. And like you can just see her in a cape and on a broom with the hair. So it's lose-lose either way. If you tie it back, she looks severe like Miss Trunchbull. And if you let it fly loose, she looks exactly like everybody's been saying she does. Like a witch. And I'm sorry, but I am commenting on it because I'm sorry, this trial has had way too many coven-like coincidences. Black box color. Well, she did appear to darken her hair, but I wouldn't say that it's black. Let's get to it, shall we? Boy, I wish I could just stream Recovery Addict's earlier stream because his audio is so much better. But I don't want to do that without his permission, and I don't know him and I don't have his permission, but his audio is so much better than Law and Crime. It's not even funny. So we're just going to have to go to Law and Crime though, because I don't want to burn any bridges, and I haven't reached out to him and I don't know how. But I do want to say I did send all of you. Hold on. I sent all of you over there to watch this morning because his coverage is really great. I love his voice. He sounds like a golf announcer, and the way he covers trials is just like you're watching a really exciting golf game. Like he'll say things like, "And the judge is stretching. He's getting up from the bench and he's stretching. They're talking about a scheduling conflict next week." I mean, it is the most hilarious thing ever. It's great. I love his coverage. And he also is like super technical and good with his sound, and he's got everything working, and I love it. But I can't snipe his stream. Actually, his morning stream is over, so I could technically just comment on it, but I just don't want to piss him off. All right, so we're going to go over to Law and Crime. So something that happened, I'm going to skip over the arguments that happened this morning. We're going to go straight to the testimony of Sally Smith. Now, we did find out, though, that the Siri rerouted her to a Waffle House that, according to Judge Carroll, happens to everyone who comes to this courthouse. They all go to the Waffle House on accident because of a GPS malfunction. So they had to wait for her. And then, this is important. The emails came in, and the jury was allowed to read Beata's emails to herself. Unfortunately, I do think that was a big win for the defense. They can really demonize Beata with those. They can make her look nuts with that, even though, we don't agree, but that's just the way it is. It came in. So the jury was allowed to read them. And they didn't even have to come in with a witness. So I thought that was a little strange. They just came in and the jury was just allowed to read them on their own right before her testimony. This is the moment where they call Sally Smith, child abuse doctor, to the stand. Those of you, I don't think anybody needs a recap, do you? Everybody knows what's going on here, don't you? And if you do need a recap, please go into the description of this video where you will find all my articles at pjmedia.com, and you can read recaps of my coverage on this trial. So here we go. Sally Smith, hit that like button on your way in here, guys. Like and subscribe. Make sure if you're on Rumble, hit that thumbs up and join on my locals so that you get all the notifications, meganfox.locals.com. I believe they come back from lunch right about now. They should be back already, but we are backing up because I missed it, you guys. I had family obligations today and I wasn't able to watch. I watched a little bit, but I wasn't able to really follow along. So here we go. Here she comes. I knew they were going to have her put her hair down. I just knew it. All right, hold on. StreamYard is already screwing with my camera. Hold on. We're going to reload. All right, let's see if it got any better. Oh, those of you asking about Hangry Fox, we had a miscommunication about the time of it, and it's actually happening right now. So his father had to go. I had to take my oldest daughter for her road test, and we don't know how that went yet. We think it went okay, but Hangry Fox is probably doing his thing right about now, and Mr. Fox might be support him.
I do.
Come this way. You can have a seat and stand there.
At this stage of the game, Sally Smith decides to take out about 18 binders and build a binder fort around her. Much like Darrell Brooks with his box fort. I thought this was kind of hilarious. It made me laugh. And I see that my camera is still freezing. I may have to do an entire reboot, you guys.
Good morning.
Tell us your name, please, ma'am.
Sally Marie Smith.
And what is your occupation?
I'm a pediatrician.
And where do you presently practice your profession?
I'm a partner in a pediatric general practice in St. Petersburg called Fifth Avenue Pediatrics.
And you have several other pediatricians that work with you in that practice?
Yes.
Okay. And that's basically a private practice of pediatrics?
It is.
Okay. Would you give the jury a brief, I think the jury's heard some of this, but if you give the jury a brief overview of your background and training in your profession, please.
Okay. My undergraduate degree was Bachelor of Science in Biology from Georgetown University.
Sally Smith building a binder fort.
St. Louis University School of Medicine and graduated in 1984. Pediatrics is a 3-year training. And so I did my first year and a half of my pediatric residency at what was then All Children's Hospital. And then I moved back to St. Louis and completed my residency at Cardinal Glennon Children's Hospital, which is the children's hospital affiliated with St. Louis University. And I did an additional year of training in what they call ambulatory pediatrics. I sort of had a career path trying to be a teaching general pediatrician. And so that was the focus of that additional year of training.
Okay. And did there come a point in your career at which you became interested in child abuse pediatrics?
Yes, actually, when I was in medical school.
Tell us how that came about and how you developed that specialty.
I believe I actually became interested first because of some children that were in the ICU when I was a resident who had
binders full of lies. Binders full of lies. Boy, would I like to get my hands on those binders.
so when I did my I'm sorry, that was in medical school. I got ahead of myself. In medical school, I did a rotation with the county medical examiner who ran the morgue in the city of St. Louis. And because I was interested in pediatrics.
All right, guys, I can't do it. I'm going to have to do a full reboot. I'm sorry. The camera is freezing too much, and I have a feeling that it's going to shut me down. So you guys know what to do. You're still coming in here anyway. If you need a cup of coffee, go and get one. I'll be back in about 3 minutes. Please just hang in there while I reboot my crappy computer. Be right back. All right, and I'm back. All right, and now I have to find my spot on YouTube again because live video always does that. Is my camera still doing it? Oh, God, of all days. Of all days. I may have to turn my camera off if it's going to keep doing this. I don't know what the problem is. Damn.
Pretty high level. That increased my interest. And then in my fellowship in ambulatory pediatrics, I worked with the director of the sexual abuse evaluation and graduated in 1984. Pediatrics is a 3-year training. And so I did my first year and a half of my pediatric residency at what was then All Children's Hospital. And then I moved back to St. Louis and completed my residency at Cardinal Glennon Children's Hospital, which is the children's hospital affiliated with St. Louis University. And I did an additional year of training in what they call ambulatory pediatrics. I sort of had a career path trying to be a teaching general pediatrician. And so that was the focus of that additional year of training.
Okay. And did there come a point in your career at which you became interested in child abuse pediatrics?
Yes, actually, when I was in medical school.
Tell us how that came about and how you developed that specialty.
I believe I actually became interested first because of some children that were in the ICU when I was a resident who had bad injuries. And so when I did my in medical school. I got ahead of myself. In medical school, I did a rotation with the county medical examiner who ran the morgue in the city of St. Louis. And because I was interested in pediatrics, she had me review all of the pediatric deaths from abuse that she'd seen.
Ah, this is low. Bring up dead babies in front of a jury and make them picture dead children in a morgue.
For a period of maybe 10 years leading up to when I was there. And that got me very interested in the idea. And then as a resident, I saw additional children that increased my interest. And then in my fellowship in ambulatory pediatrics, I worked with the director of the sexual abuse evaluation program at Cardinal Glennon Children's Hospital. I worked with them like once a week or close to that, seeing children in their sexual abuse evaluation program.
Did you subsequently undergo additional training in child abuse pediatrics?
So because of when I started this, which was in the late 80s, there wasn't really what's called fellowship training in child abuse pediatrics. So what I ended up, learning over the years was mostly through experience. And beginning in 1988, I was the director of a sexual abuse evaluation program in New Brunswick, New Jersey at the Robert Wood Johnson University School of Medicine. And I was a teaching general pediatrician there. And then in 1990, I moved back to Florida, and I actually took a general pediatrics faculty position at All Children's Hospital. And as part of my job, I asked them if I could work with the child protection team. And so from there, I just ended up seeing virtually all the children that have come through All Children's Hospital for the last 32 years who needed evaluations for alleged child abuse and neglect. So I gained my training, if you will, in the trenches, just seeing children, looking things up, reading about it, checking with expert colleagues, learning from the radiologists, the neurosurgeons, the other people who work with these children down at All Children's, and ended up acquiring a pretty high level of expertise.
Did there come a point in time at which
Those of you commenting on how she's breathing, remember she was late for court. She was running into court carrying all those binders. So I'm thinking that she's breathing like that and out of breath and shaky because of that, because she does calm down after a while.
you applied for board certification in child abuse pediatrics?
Yes. So in 2009 was the first year that a board certification was made available for the specialty of child abuse pediatrics. And at that time, as I mentioned, because there wasn't really a fellowship in child abuse pediatrics, which would be 2 or 3 years additional training, the people who were allowed to sit for the exam could also be people who had at least 5 years experience in evaluating children for child abuse, were working in that specialty for at least 20 hours a week, which I qualified for both of those. And also you needed to have essentially a letter sent to the American Board of Pediatrics from someone who was kind of a recognized expert in child abuse, who would sort of vouch for you that you were a person that should be allowed to take the exam. So I took that exam, I believe in November of 2009. It was in the fall. And then I think early January was notified that I passed the exam and therefore was board certified in child abuse pediatrics.
Okay. Now, did there come a time in your career at which you became involved with the child protection team for Pinellas County? Yeah,
so I worked for All Children's. I'm going to keep leaving out the Johns Hopkins because I've just been using that term for 32 years. But anyway, when I went to All Children's to join the faculty, I started working with the child protection team in Pinellas County. And the hospital basically had an arrangement where they billed the child protection team when I saw cases for them for the hours that I worked, and allowed me to have the time to do that. And so for that 12-year period when I was working for the hospital, I was on campus. And so vast majority of the children who were hospitalized, where there were allegations of child abuse and neglect and a medical evaluation was requested, I did those evaluations. So I was a consulting pediatrician for the child protection team during those 12 years. In November of 2002, their medical director left, and they asked me if I would take over as the medical director. So at first I tried to work out a way to keep my job at All Children's and also do that, but it wasn't really very practical. And so I ended up resigning from All Children's at that time. And
so that you guys know, I understand. I know you guys are all chatting about it in the chat right now. I understand that she was confronted by one of the wrongfully accused fathers outside of the courthouse. Those are the reports that I'm hearing, but I have not yet seen any footage. No one's reporting it anywhere so far. Those of you who are paying attention on social media are kind of like, let me know if you find a link to that. There must be some footage of it somewhere. I also have the appeal of that father. I'm pretty sure it's his because he's the one who went to jail, if I believe, if I'm getting the right guy. He's the one who went to jail because of her false allegations for shaken baby syndrome when his baby had a rare bone disease that caused bone breaks that she mistook for abuse. I do have the entire appeal. It's 198 pages. I was reading through it last night, and let me tell you something. Here's something that is not the jury's not going to hear. In that case, his attorneys, who, and I believe this is the same father who confronted her today, In that appeal, his attorneys claimed that Sally Smith acted as a prosecutor and did not disclose her previous bouts of false allegations where she had been proven in court to have been wrong. The defense, and this is in a criminal case of child abuse, the defense asked Sally Smith, have you ever been accused of or been proven to have made false child abuse allegations? She said no. In the same year, I guess USA Today wrote an expose on her and how many child abuse claims she got wrong. And so his defense team used that information to come back and appeal his sentence and say, basically, they didn't use the term Brady, but in my understanding of Brady, if she's working with the prosecution and the defense asked the prosecution for evidence that this woman was guilty of false child abuse accusations and found to be, it was found to be false in a court of law and they didn't turn that information over, that's exculpatory evidence. They didn't turn over exculpatory evidence. That very thing I want you to keep in your mind, that Sally Smith already once that we know of has not turned over exculpatory evidence. When we get to the end of this with the proffer at the very end, you're going to hear that Sally Smith did that in this case too. She withheld exculpatory evidence from her report, and she thinks she's perfectly fine to do that. She said that's up to your lawyers. That's up to Beata's lawyers to prove she didn't do it. I mean, it's going to make you very mad. I'm going to have a hard time telling jokes today because what I'm seeing, my heart is pounding, my blood pressure is rising, because this is the thing. She is not an objective observer. She works for the state as a weapon, and her only purpose is to find evidence against you of child abuse and prosecute it. She's not interested in exculpatory information. She's not interested in exculpatory evidence, which means evidence that would prove you were not guilty. And she will willfully leave it out of her report. She will willfully lie under oath and say that she never had any false allegations of child abuse, that she's never been accused of that before, like she didn't. And so there's no wonder if that man confronted her outside of court and screamed at her. I would too. He went to jail. I think he was in jail for 3 years. I don't know. I don't know. We'll have to confirm that. But those of you, if you're on Locals right now and you have access to the live chat there, if you're a Locals member and you find a chat, you can post it in there. I mean, if you find evidence of the confrontation, you can post it there so I can get it, or you can find me on Twitter at Megan Fox Writer and post it there. I would like to show that on the stream if we find it, because I'm sure somebody got video of it. No way did he confront her without having somebody videotape it. So let's continue on here.
And became the medical director for the child protection team. So for Pinellas County, that's about a 20-hour a week.
Okay, it was 8 months.
26, I believe.
So you went to jail for 8 months?
About a 20-hour per week job. And
so
I did that, and within a few months, I started working at this private practice where I still am.
Okay. Let me back up a little bit there and try to clarify a couple of things. You indicated you resigned from what was then just All Children's Hospital,
right?
No Johns Hopkins,
right?
In 2002, is that right?
Correct.
And at that time, you became the director of the child protection team for Pinellas County, correct?
Right. The term they use for the physician is the medical director. So I was the medical director.
So what is a child protection team and who constitutes it? Who were you working for at that time?
So the child protection teams, Florida has a kind of a model program for the country. And it was set up in the late 70s. I think that All Children started.
Sorry?
Sustain.
Can we approach him?
Sure.
All right, sidebar. That's another great thing about watching Recovery Addict is that during the sidebars, he's listening in on the Zoom link. And if he can hear it, he repeats what they're sidebarring about, which is great.
If we can, without a history lesson.
Okay, sure.
The CPT, well, let me back up. We talked about that you resigned from Johns Hopkins from All Children's Hospital in 2002.
Right.
And have you ever worked for them or been employed by All Children since then?
No.
Have you ever been employed by Johns Hopkins All Children's Hospital?
No.
Or Johns Hopkins?
No.
Okay. Without going into the historical details, well, let me lay it back this way. When you saw Maya Kowalski in 2016, were you the medical director of the Pinellas County Child Protection Team at that time?
Yes, I was.
And you had been so since 2002 in one role or another.
Correct.
And tell the jury, if you would, what a child protection team is.
Okay.
Objection to Candy. No, she can answer that question.
So in Florida, each county is covered by a child protection team. It's a multidisciplinary team that includes a medical director, usually nurse practitioners or sometimes other physicians from the county who are supervised by that medical director, and social workers who serve as what are called case coordinators. So they communicate with all the people involved in a particular investigation or case. And they also have like a team psychologist, for example, that's contracted, a team attorney, I believe. So it's a multidisciplinary team with these members, and it provides, especially in Pinellas County, one of the biggest functions of the child protection team is to provide medical evaluations when there are allegations of child abuse and neglect. And there are certain criteria that are set up under statute in terms of which kinds of situations warrant a medical evaluation. And so we kind of follow that list, if you will, in responding to requests for evaluations. The vast majority of the time, the request is made by the Child Protective Investigation Division under the Department of Children and Families. The child protection teams are under the Department of Health in Florida. And so they work side by side, but DCF doesn't run the child protection teams. And so they request for us to help them in investigating their case by looking at the medical information and guiding them in terms of whether there's medical evidence that would support a diagnosis of child abuse and neglect, and whether a child's safety is at risk as a result of that.
Okay. So in any given situation of a child abuse investigation, what is the role of the child protection team and its medical director in pursuing that investigation or facilitating that investigation?
So primarily the role is to provide that medical evaluation, and it kind of varies exactly how much work is required to do that. But also we end up being a go-between with the dependency attorneys, the child protective investigators, the detectives or law enforcement that may be involved in a case, again, to provide that medical expertise to assist everybody in making a good decision for the child. We present information in court on a fairly regular basis and assist the dependency judge or the juries in evaluating the cases for whatever legal action may be needed. And one of my roles, which is also in statute, is to provide education for community medical providers.
And how much do you think they pay her to do all this? Because believe me, this is not free services, by the way. She's a contractor. There's big money in this. She's doing education. She's in charge of, she goes into how she's in charge of rotations when it comes to training at the hospital. She's in charge of all kinds of stuff. She's on the boards, a lot of money. And I don't think in this testimony, we got into how much she's paid.
So in that role, particularly for a teaching hospital like Johns Hopkins All Children's Hospital, it's important. The residents are required to have a certain amount of training in evaluating child abuse and neglect. And so over the years, I've been involved in that element as well to help provide education for the medical students and residents there at the hospital.
Okay. And do your statutory duties as medical director of the CPT, in your understanding, require that you consult with healthcare providers in a situation where a child has been sheltered?
There certainly are scenarios in which that's an important component of what were my responsibilities. Not always, but many times, especially in more complicated cases, the treating physicians at the hospital may need an ability to consult someone who is more expert in child abuse or neglect case for a variety of reasons.
Now, in the fall of 2016, and particularly in September and October 2016, You told us that you were the medical director of the Pinellas County Child Protection Team at that time.
Correct.
What other hats did you wear as a pediatrician?
And were they pointy?
So I had my private practice.
Did you wear
at that
any
time I was working half time.
particularly pointy hats? Which hats did you wear? And were any of them magical in any way?
I'm there now. I'm full time. And I also, ever since I moved to Pinellas County in 1990, I had active medical staff privileges at All Children's Hospital. I do to this day. And that doesn't mean anything about being employed by the hospital or being somehow under the hospital, but the medical providers that go in the door there have to have credentialing in order to go in and see patients.
Well, except for that guy that works for DCF. Remember the psychologist who lost all his notes because the hurricane ate his homework? That guy didn't have to have any credentials. He walked right in and gave Maya IQ tests and then wrote down a bunch of lies in pencil on paper that disintegrated shortly after he left. Remember that guy? He didn't need any credentials.
Communicate with the other physicians, review the medical records and the radiology studies and lab work and all those kinds of things. And so that was essentially another hat where I was active medical staff at the hospital. And then as a community pediatrician, and obviously I'd been there for 12 years, so I was well known to the medical staff members, and they asked me to be a representative on a number of hospital committees over the years as a representative of the community to sort of bring that to the table. So I think at the time in 2016, those were the main additional roles that I had besides being the medical director of the child protection team with regards to All Children's.
Okay. At that time, in the fall of 2016, did you have what we refer to as staff privileges, medical staff privileges at hospitals other than Johns Hopkins All Children's?
Yes, I believe the only one as of 2016 would have been Bayfront Medical Center, which is Orlando St. Pete now or something, where I've had privileges since 2002 to see newborns in the nursery there. I mean, I have staff privileges, but that's what I actually.
And tell the jury, how did you survive the Salem witch trials? That's hilarious.
Actually use them for.
Okay, so you would have privileges to practice both at Bayfront Medical Center and at Johns Hopkins All Children's Hospital.
Yes, and in addition to being able to walk in the door and evaluate children as the medical director of the child protection team, in 2016, I still had some patients from my practice that were complicated patients that sometimes I would admit to the hospital and manage their care. That was a different hat. That's my private practice side.
Does that hat have horns on it?
That's all been taken over by the hospitalists in recent years, but I used to do that multiple times a year, admit my own patients to the hospital.
Okay. Now, in this particular case, how did it come about that you became involved with Maya Kowalski?
So the main way I became involved was because there was a report concerning child abuse or neglect.
I'd like to say thank you to my locals peeps who made the memes today and made the thumbnail. Thank you for that so much. Locals chat is hilarious. They have made memes with the Wicked Witch of the West, and they've made some with the witches from that movie where the kid gets turned into a mouse. Remember that one? Which hat did Satan give you? It's a good one. Unhung Hero, thanks to the super chat, says, are we sure she didn't look like something that rhymes with witch? Ashley Casey, thank you for the gifted membership. I appreciate that. And Bozena Saikala, thank you for the super chat that says, thank you for everything that you do. Well, I appreciate you guys. Thanks for being here and putting up with my crappy computer. And I'm sorry that my camera is freezing again. I don't know how to make it stop. So we're just going to keep on going. We're just going to try to continue. So let's fast forward through the sidebar.
Continue, Mr. Hunter. Thank you, Your Honor. Please go on. Let me focus this a little bit.
Okay.
In early October of 2016, did you receive a call regarding Maya Kowalski from Dr. Beatrice Tepa-Sanchez?
Yes, I did.
And at that time, when you received that call, did you have any knowledge of Maya Kowalski or her admission to All Children's Hospital?
No, that was the first I learned of it.
Okay. And Dr. St. just contacted you regarding concerns that she had.
Oh yeah,
Yes.
Rumble. I'm sorry.
And
I did
what
just see
did
your
you do
rants.
to tell us very specifically.
Over on Rumble, Palmyra Productions, thanks for the Rumble rant, says her job is not interest in children. Her job is to keep case open, to keep using CPS resources. So by the end of the year, CPS gets more and more of that sweet, sweet state money. That is correct. That is correct, Palmyra Productions. Absolutely. That is her job is to justify her existence. She can't justify her existence if she doesn't take more and more children every year. It's truly like a Hansel and Gretel story.
And not at any length, if you would, what you did in response to that phone call.
I talked to her on the phone about, she was asking me about what to do about a possible case of, I believe her terms were Munchausen syndrome by proxy. And we talked about the kinds of things that are needed to assess that diagnosis, such as medical records.
Objection as to
Oh, you can continue.
Good. Sorry.
Wait, is this Dr.
And we
she
also
just-
talked
talking about Dr.
briefly, as I
Hold on.
recall, about this.
Stop. Was she just saying, did she just reveal that it was Dr. Pepper in the PICU with the telephone who made the call? Because I didn't think I knew that before.
What you did in response to that phone call.
Hold on. Yeah, it
I
was.
talked to her on the phone.
Check it out.
And what Dr. St. just contacted Children's Hospital, knowledge of Maya Kowalski or her admission to All Children's Hospital.
No, that was the first I learned of it.
Okay. And Dr. St. just contacted you regarding concerns that she had.
Yes.
It was
And-
Dr. Peppa Sanchez in the PICU with the telephone. We now know who made the first call, and she didn't call the hotline. No. She called their internal investigator, Sally Smith.
And what did you do to tell us very specifically and not at any length, if you would, what you did in response to that phone call?
I talked to her on the phone about, she was asking me about what to do about a possible case of, I believe her terms were Munchausen syndrome by proxy. And we talked about.
Wait, did she say about a woman who has it or that they think has it? Because
Terms
that
were Munchausen syndrome. Asking me about what to do about a possible case of,
possible
I
case.
believe her terms were Munchausen syndrome by proxy.
Okay.
And we talked about the kinds of things that are needed to assess that diagnosis, such as medical records.
objection as to
Oh, you can continue.
Good. Sorry.
And we also talked briefly, as I recall, about this specific case. And I tried to give general advice in terms of how pediatricians can approach concerns for Munchausen syndrome by proxy, or what I prefer to call medical child abuse.
And the
And
reason
were you called?
the reason she prefers to call it medical child abuse, I know I've been over this with you guys before, but I've been covering these cases for 20 years. And the reason why they're moving away from Munchausen syndrome by proxy is because everybody knows it's bullshit. Everybody knows now when they see Munchausen, it's like, that's like some kind of Hollywood made up shit. That you're sensationalizing just regular old child abuse and making it out to be something that it makes no sense. It only affects women. It's a mental disorder that only affects women. The amount of men who have been charged with Munchausen has been like 2 in the history of this so-called disease. So what do? They start calling it by a different name, factitious disorder. And now they took the Munchausen out of the DSM-5 and they replaced it with factitious disorder. And sometimes now they call it medical child abuse. Why the hell don't you just call it child abuse and let it be a criminal problem, like a crime? Child abuse is a crime. Because you know why? Because they didn't have enough evidence to charge her with a crime. They had no evidence at all, which is why they called this woman to gather and gin up evidence against Beata Kowalski, because they didn't have enough evidence to call the hotline. And that's going to come out in her testimony. They didn't have enough evidence to call the hotline, so they called her. And she comes in with the power of the state, with no authority, no warrant, no nothing, starts investigating them and to make up information to get their kid taken away. That is exactly what she did.
Called at that point as a member of the child protection team or as a medical staff member at Johns Hopkins All Children's Hospital, or do you know?
My understanding was I was being called as the person they all had known for 32 years to be the hospital expert in child abuse and neglect, as an active medical staff member, and another active medical staff member was seeking my assistance, advice about what to do about a case where there was concern.
Now, with a call such as that, would that be considered a consultation?
That would be my understanding of what that's what I thought it was.
Did you access the medical records from Maya Kowalski at that time?
I believe I did briefly, yes.
And did you take any further action as far as evaluating the patient herself and her medical care at that time?
No, because to do anything as a child protection team medical director, I need to be asked by the investigators to provide a medical evaluation.
There we go.
And at that time,
Here we go. She needs to be asked by DCF to do any kind of investigation, not a doctor at the hospital. She needs her authority from DCF. Somebody has to call DCF. So now she's colluding with Dr. Peppa Sanchez about how to get that phone call so that she's got the authority. But I wonder what the hell happened in between.
to my understanding, there was no actual investigation ongoing yet.
Nope.
And Dr. Peppa Sanchez wasn't the person under Florida law who can ask me to provide that medical evaluation.
So under the law, she's not the person who can do that. So why'd she make the call to Sally? Why didn't she call the hotline? We're going to find out.
It was a Saturday, as I recall, 1-ish in the afternoon. And we had a little discussion at that time. And then I honestly didn't think about it more, do anything more about it until Monday when I got that referral where the child protection team was asked to provide a medical evaluation.
Yeah, we're supposed to believe that over the weekend, she didn't scheme and plot to make sure that phone call to DCF happened. Who called DCF? Was that Dr. Peppa Sanchez in the PICU with the telephone too? Or was it somebody else?
Evaluation.
So between the time you spoke with Dr. Peppa Sanchez and looked at the chart briefly, and the time you were advised of an investigation on Monday morning,
As I recall, it was Monday morning, yes.
did you take any action to render diagnosis, care, or treatment to Maya Kowalski?
None whatsoever.
And so you had a brief telephone conversation, and until you were told there was an investigation, you took no other action to involve yourself in this patient's care.
Correct.
Now, once you were advised of the investigation, did you undertake well, first of all, and I want you to answer this question very narrowly.
Okay.
Were you advised of an investigation and asked to conduct
Time for
a
laundry
medical
folding.
evaluation as the medical director of the child protection team?
Yes.
And is that the point at which you began your investigation of the case?
That's the point at which I began my medical evaluation of the case. I wasn't the investigator. Those are other people. I was providing a medical evaluation for the child protection team to assist those other people.
Okay. And in conducting that investigation, were you acting as a medical staff member of All Children's Hospital, in other words, a pediatrician in consultation, or were you acting as the medical director of the child protection team?
You know, there's a slight overlap because the privileges that I have at the hospital allow me to review their records and enter the building and examine children and things like that. So there was a slight element of my active medical staff credentialing that was in play, but primarily I was acting as the medical director of the child protection team.
Who was conducting the care of Maya Kowalski at that point?
At that point,
But you accessed her medical records before anybody gave you legal authority to do so. And if you're not a doctor at that hospital, like they're trying to say that, no, she just works for DCF. She doesn't work for Johns Hopkins at all. She's not a staff member there. Well, then she shouldn't have access to files, and she shouldn't be able to get those files unless she has a court order to get them. I want to pull up this super chat. Duncan, Idaho, thank you so much for the super chat. It says, 1, report evidence or suspicion of a crime. 2, law enforcement follows up, obtains a warrant for info and medical records if they can. 3, all parties are aware that they're being criminally investigated. And that's what a lot of this comes down to. Beata Kowalski and her family had no idea they were being investigated when this investigation started, which means they had no notice of it. They didn't have Miranda rights. They didn't know they had the right to remain silent. They didn't know they had a right to an attorney. They didn't know any of those things. And they didn't know that they should be silent. They didn't know to invoke their Fifth Amendment rights. They didn't know any of this. This is not how America works. It's not how it works. T-Rex, trucking, and more. I dig the Wicked Witch of the West thumbnail. We'll thank the Locals crew for that, because over at meganfox.locals.com, they're working really hard on a bunch of hilarious memes. And that was one that I couldn't have done without their help. So yeah, this is insane. Insanity.
She was in the pediatric intensive care unit at All Children's. And so the ICU physicians, the pain management team, I'm not sure if there were any other consultants that were involved at that point. Certainly all the nursing staff and the support staff and everything were the ones that were managing her care. In not just this case, but in child abuse cases, I don't really get involved with the management, day-to-day management of the children at all. My role is specifically to do this medical evaluation. And so I focus on that part and not really anything related to,
that's her role,
whether the child gets a regular diet or what medications they're on or how often they're getting vital signs or any of that kind of thing.
And is your involvement?
Joe Kelly, happy birthday. Joe says, thank God you're here, Megan. It's my birthday, and I haven't seen anyone be mean enough to this slime ball. Well, you've come to the right place. If there's plenty of other streams out there where you can go and have, safe spaces in the chat. But here we encourage you to be yourself. We encourage you to let it all out here, because you got to be able to let it all out somewhere. So my only rule for the chat is to just avoid the words that YouTube really hates and will flag the channel for. But as far as your free speech rights are concerned and how you feel about government abuse and government abusing this family, I am 100% in your corner. I am 100% in favor of your ability to express yourself freely. And if that means name calling and it means mocking or ridiculing somebody in somebody's hair, I don't give a shit. Do it, because it's not, it's not juvenile. Okay, maybe we're a little juvenile here. It is your God-given right to speak out about and criticize government officials. It is our duty. It is we are required to do this. We are required to put her in a meme. She works for the government. She represents your government. And if you think that I'm beneath, I'm somehow above, not beneath. If you think I'm above ridiculing government actors when they violate civil rights, you've got another think coming. I have no reserve about that. They all deserve it. These people did bad things, period.
Involvement in the medical evaluation as the CPT medical director, in your understanding, part of your statutory duties as the medical director of the Child Protection Team?
Yes.
With respect to Maya Kowalski, did you ever write a consultation in her chart?
So the physicians that are treating the children that I see down there for a child abuse evaluation obviously are going to be helped if they know all of the medical data related to that potential diagnosis. And so recently there's a different electronic medical record system and it doesn't exist anymore. But at the time that I was involved with this case, what I would routinely do would be to provide my medical report to the treating physicians at the hospital to assist them. And that's okay when they basically ask me if they can have my information, my report, then I can provide it to them. There was a sort of a super confidential kind of process that was set up so that not, the housekeeping staff couldn't look at these medical records, but a physician who was logged in that manner could see the Child Protection Team report and could, utilize that for either that time they were in the hospital or maybe a subsequent time they were in the hospital. That doesn't really occur the last 4 or 5 years or so, but that was in place at that time.
But your report would not have been placed into this portion of the chart you're referring to until you actually rendered it, completed it, and signed it much later, correct?
Typically correct, yes.
Okay. When you are in private practice, when you're managing a patient, let me ask you this way. When you're managing a patient in a hospital, whether it's Bayfront or Johns Hopkins, wherever, and you call for a consultant, a specialty consultant,
Yes.
what typically happens? You get a consult report in the chart?
Right. I mean, I had many years of experience, like as an actual in-hospital person, and that's what's typical. A consult order gets written. In this case, it's different because there's no consult in the all children's medical record for a child protection team evaluation. That has to go through child protection team and child protective investigations in the state of Florida. So there's never a consult order for a child abuse.
So it's not a thing the hospital doctors are supposed to do is investigate a family. Huh. That's interesting because I do remember Dr. Peppa Sanchez saying that she was doing a side-by-side investigation with the child protection team. I remember her calling it my investigation. She wanted that video footage for her investigation as well as the child protective team. Well, that's interesting because Dr. Sally Smith here just said there's no order anywhere in the hospital for anything like an investigation because they're supposed to be there to heal your kid and treat you as a patient. Or maybe it was Paula Dees, one of them. It was either Dees or Peppa Sanchez. No, I think it was Peppa Sanchez who said she had a investigation going on.
Evaluation from a hospital physician. What they do is they make a report, or their typically social worker that's involved with the case makes a report to the hotline. That's how it works in Florida. That's how it works at All Children's.
Okay, so during the time that Maya Kowalski was at All Children's, did you ever write an order in her chart?
No, I did not.
Did you ever write a progress note in her chart?
No.
Did you from time to time talk with the physicians that were caring for her?
Yes.
But did you see her or round on her on a day-to-day basis?
No, I saw her one time, I believe on October 13th, 2016. And I saw her one time in early November, probably between 5 and 15 minutes each time. Those are the only times I ever saw her while she was in the hospital.
She saw Maya two times. So here's what I want you to understand about child abuse doctors. Almost every child abuse doctor that I have studied in these corruption cases that I have written about for pjmedia.com, in all of these cases, almost all of them, actually all of them, I can't think of one that this didn't happen. The child abuse doctors never spoke to either the mother that they accused of Munchausen, and in most cases, she's on the rare side that actually met the child. And she only met the kid twice. Mostly, they don't meet the kid or the parent. They go through the records and they accuse based on simply the records alone. And we're going to find out she never even met Beata Kowalski. This is the same thing that happened in the Cynthia Absug case. The doctor who accused her of Munchausen never met her and never met her son. He was simply looking at, he was the same exact person as she is in Broward County, Florida. Same exact job. And he looked at the records and he said that she had this and the kids were being abused. And the sheriff in Broward County said, no, unfounded. But then when she was in trouble in Colorado, because it's a whole long story, that Colorado DCF looked at the old records in Florida. They ignored the exculpatory sheriff's investigation that said it was unfounded. And they took the child abuse doctor who had never met her, never met her son, and they put that in front of a judge in Colorado and made that the reason why they took her son, even though a sheriff had investigated it and found it unfounded. They left that out completely from their report. They fabricated a report. They did exactly what this woman is going to do. She's going to fabricate and leave out, because fabrication means more than just lying on a report. It is the omission of exculpatory evidence. Talk to Sean McMillan about that. He wins millions of dollars from these places because he can show that they did not put exculpatory information in their reports, and they are required by law to do so. Their own training. And I was very disappointed in Anderson today when he did not bring up her training and find her training that said she is to be honest and complete in all reports. And in order to be honest and complete, you must include exculpatory information. They never do. They never do, because they act like unethical prosecutors.
And what was the purpose of your seeing her those two times?
So part of my medical evaluation is supposed to be a physical examination. So when I saw her on October 13th, I was trying to perform a physical examination, which basically she declined. So in November, again, as part of my job as the Child Protection Team Medical Director, I'm supposed to do a physical examination, and I'm also supposed to provide photo documentation for investigators and whoever else is involved in the case.
Of a half-naked
So I
kid?
went that day in early November to try to take some photographs of her lower extremities in terms of trying to essentially document the absence of a problem.
And did you take any such photographs?
I did not.
Why not?
Did you ever interview Mr. or Mrs. Kowalski?
I took as part of my medical evaluation, I took a fairly extensive history from Mrs. Kowalski and a much more abbreviated history from Mr. Kowalski. The meeting with Mrs. Kowalski took place on October 11th. And
Oh, I'm sorry. This one did meet with Beata. She did. Oh, that's right. I forgot. Remember, because she told them she was the what did she say? She was with the Child Protection Team. It was the other child abuse doctor in the other Florida one in Cindy's case who never met her. This one did meet with her, but she's not a psychologist. She's not a psychiatrist. So she can't diagnose her. She took and they thought at the time, they didn't know they were being investigated by basically a police officer. She has the power of arrest. She has the power of seizure. She can seize your child from you. That is technically an arrest power. And they didn't know. They didn't know they were being investigated when she took this extensive history. They thought she was trying to get to the bottom of what was wrong with Maya.
2016 and the relatively brief interview or history taking with Mr. Kowalski occurred on October 13th.
Okay. Did you ever speak to the two of them together?
I did not.
When you spoke with Mrs. Kowalski.
So one meeting. One meeting. Big deal.
First of all, where was it?
So at that time, Maya was still in the pediatric ICU. They have a family conference room kind of thing outside of the main entrance to the pediatric ICU. And because of the investigation that was being initiated and everything, I scheduled a time where the child protective investigators and the people in law enforcement that were investigating the case could join me while I took my medical history. So as I recall, there were about 5 of those people, 2 or 3 child protective investigators, I think 2 law enforcement people, and Mrs. Kowalski. They were all in that room already when I got there for the scheduled meeting, which I believe began at 5:45 in the evening on the 11th.
Okay. Did you identify yourself to Mrs. Kowalski?
Absolutely.
How did you identify yourself?
I always say, I'm Dr. Sally Smith. I'm a pediatrician with the Child Protection Team. And that's what I said to her.
And nobody on earth would know that wasn't a team within Johns Hopkins. Nobody would know. They don't know the code words. I would know. The second I heard it, I would know, but that's because I'm a journalist who's been covering these stories for 20 years. There is no way that a normal person would know when you say, I'm with the Child Protection Team, that you're not just with another team in the hospital. No freaking way. What they should be required to say is, I am an investigator with the Child Abuse Team, and I work for DCF, the Department of Children and Family Services. You have the right to an attorney. Anything you say may or can or will be used against you in a court of law. You have a right to an attorney. You can leave at any time. You have a right to invoke your Fifth Amendment rights. Do you want to talk to me? That's all they should be able to say. It is absolutely outrageous that a person with the power to seize your child, to do a warrantless seizure, and they do it all the time, does not have to tell you ahead of time that anything you say to me can and will be used against you in a court of law because I am building a case against you for child abuse. So you have a right to remain silent. I am so tired of this. This is the whole problem with Child Protective Services. This is police power. This should be checked by the state. They are using subterfuge to get parents to say things that will incriminate them, to get them to act against their own self-interest, which is against our Constitution. This should be banned. This practice should be completely destroyed. I'm not going to make it through today. I'm going to have to get the whiskey out. Oh my God.
And the other folks who were there were either law enforcement or child protection investigators?
Yes. It's possible that one of the nurses was in there, but otherwise, those were the people that I recall being present.
Were you wearing a lab coat?
No.
Do you ever wear a lab coat at all?
Well, at All Children's, no. I do in my office now since the pandemic, but for 20 years, I never wore a lab coat.
Do you wear, when you're in a hospital, do you wear a particular identification badge?
Yes, I have to wear my Johns Hopkins All Children's identification badge to come in the door and to, move around. There's all these little things you put your badge up to open doors. And I have a similar one for Bayfront.
Okay. So if you're in Bayfront, for example, you wear a Bayfront badge. If you're at All Children's, you wear All Children's badge.
Correct. And when I go in between, I switch badges.
Okay. When you spoke with Mrs. Kowalski, was there any question that you had identified yourself as a member of the child protection team?
Absolutely none.
And did you conduct that investigation in any way as an employee or agent of All Children's Hospital, Johns Hopkins All Children's Hospital?
No.
Did you ever hold yourself out to Mrs. Kowalski as acting on behalf of Johns Hopkins All Children's Hospital?
No.
She didn't have to.
As I said,
She didn't have to. She's wearing a badge. She said she's part of the whatever team. That is holding yourself out to be a part of the team. That is. You're on all the team emails. You're on the treatment team emails. Everybody thinks you're a treating doctor. It doesn't matter if you are or aren't. They think so.
This is a scheduled meeting. Everybody knew exactly what was happening.
No,
Absolutely.
I did not know what was happening. They did not know. I want to know, were they told everything they say in this interview can and will be held against you in a court of law? Can and will be held against you in a court of law. If they didn't say that, then they didn't know.
How do you know, Senior?
Objection. Speculation. Sustained.
Are you aware of how Mrs. Kowalski might have known that this meeting was going to take place?
As I said, they were all in the room when I got there. So she, and I believe some of these people had already interviewed her as part of their investigation. She probably recognized some of these people. They got on.
You know what would help, Chris? Yeah, she should have a CPS badge and it should say in big letters, child stealer, government approved child stealer.
On their badges and their, work-related clothing and things like that. So,
Objection. Again, speculation. Overruled. She can say what she saw.
So, and I introduced myself. I don't quite see how it's possible that she didn't know who I was and what was happening.
Oh, give it up, lady.
How long did that meeting take place?
About an hour and a half.
And you subsequently had an opportunity to speak with Mr. Kowalski?
Yes. So,
I'll
okay.
follow up on that. When did you talk with Mr. Kowalski?
So that was on October 13th, and I'm honestly not sure exactly what time.
Okay. And how long did that discussion or meeting last?
I would guess about 10, maybe 15 minutes.
And who was present for that meeting?
The bedside nurse, I'm pretty sure she was still in the ICU that day, and Mr. Kowalski and Maya.
Did you identify yourself to Mr. Kowalski?
Yes, I did.
And how did you identify yourself?
I said, I'm Dr. Sally Smith. I'm a pediatrician with the child protection team.
And did you at any point advise Mr. Kowalski that you were acting on behalf of Johns Hopkins All Children's Hospital?
No.
Were you attired in much the same way as you were when you spoke with Mrs. Kowalski?
I was wearing professional street clothes both times.
Okay.
Prove it.
And,
Let's see the
yeah,
video.
no lab coat.
No, I would have had my badge on both times because I was in the building, but otherwise just professional street clothes.
Now, at the time that you spoke with both Mr. and Mrs. Kowalski, and I think I'm getting the dates right, around the 11th and the 13th of October, respectively, were you aware of any efforts being made to transfer Maya to another institution?
So I would say during that week, I knew that that was being investigated by, I believe, the hospital. I can't tell you exactly what day I knew that, but I definitely knew that there was an effort being made to transfer her to an inpatient intensive rehab facility.
And were you involved in that effort at all?
No.
Were you directing that effort at all?
No.
Were you directing any of the medical care of the patient at that time?
No.
And how did you know that was going on?
That's why I'm not sure exactly the time frame. I know that week, there was a multidisciplinary staffing that took place with people from the Sarasota County investigators and top.
She thinks that word multidisciplinary is gonna save her. Heather, thank you so much for the Cash App. $50 on Cash App. I sure appreciate that. Thank you so much. And I think we have a couple of super chats to get to real quick over here as well. Unhung Hero. She's Queen. See you next Tuesday of the Munch Bunch, or the Munchie Bunch. Yes. It's tough. This is going to get much tougher to watch, you guys.
Protection team and myself. And I believe there was discussion at that meeting. I believe that meeting was on the 13th, but I'm not 100% sure. But there were multiple discussions that I had with the treating physicians at All Children's that they were trying to make that kind of thing happen.
And did you have any understanding about whether there was an effort being made to wean Maya Kowalski's medication or reduce her medication as part of that effort?
I did not really, have any involvement with any of that. I believe at one point later in October, maybe right around now, October of 2016, that I, knew that was happening. Okay.
And did you, once again, did you learn of that from the physicians directing her care, or did you attempt to direct that care yourself?
I learned that from communication with the attending physician.
Okay. And do you typically follow that as part of your statutory duties as child protection team medical director? In other words, follow the course of the patient's care?
Yes. Typically when I've seen a child, and then as I'm writing my report, I kind of go back in the chart, see what's happening, put some of the quote unquote hospital course into my report, and then, reach the conclusion. This was a much more extensive, lengthy process. So at that point, at the end of October, I hadn't, done any report or anything, but I was still in communication with them related to what was happening with the child abuse part of the case.
Okay. Now, let me ask that we put up.
We don't believe you.
Trial Exhibit 2123-723 in evidence.
You sit on a throne of lies.
And let me ask you to take a look at this, Doctor. It's an email from Kathy Beatty. Do you know who Ms. Beatty is?
Yes, I do.
And did you, in fact, make a request of Ms. Beatty to get together with the treatment team
Pay attention
to talk about
here.
Maya's upcoming needs in December?
Sorry, I got my stuff in front of the screen.
Pay attention here.
Yeah, so I believe at that time I was in communication with the dependency attorneys, and there was a need to.
You can answer that question.
There was a need to present to the judge what options he could consider and choose from in terms of what the child's needs were, what the options might be for those kinds of treatments and things. And let's
wait for the next question, Dr. Sons.
All right, this is very, very important that you pay attention to what she answers about this particular email. Boosh McFadden, that's so funny. You don't smell like Santa. You smell like beef and cheese. I imagine that the jury is just like Buddy the Elf with this one. We know you're not who you say you are. I think it's very important to pay attention. She says she wasn't at this meeting, this care team meeting that supposedly Kathy Beatty invited her to on an email. Later on, during cross, we're going to find out she absolutely was at that meeting. And her excuse is, oh, I misspoke earlier. I misspoke. Oh, you mean you lied? You mean you lied under oath? That you weren't at a meeting
The jury,
that
you're
you were
going to
at?
disregard the answer that Dr. Smith was just giving. Mr. Hunter will ask a different question.
Wait.
Let me ask you.
Wait. What?
Members of the jury, you're going to disregard the answer that Dr. Smith was just giving.
What was the answer that was objectionable? I want to know. I want to know what the answer was that was objectionable. Where was she going with it? What was the question?
There was a need to.
You can answer that question.
I was in communication with.
What was the question?
Sorry, I got my stuff in front of the screen. Yeah, so I believe at that time I was in communication with the dependency attorneys, and there was a need to,
You can answer that question.
there was a need to present to the judge what options he could consider and choose from in terms of what the child's needs were, what the options might be for those kinds of treatments and things. And they
Let's wait for the next question, Dr. Size.
Okay, so it's about the court case. Again. So the defense, after saying that we can't have any Chapter 39, no Chapter 39, they're letting her talk about Chapter 39. They're letting her talk about the judge and the court case and the decisions that were made and why she was doing. They're not allowed to do that. And if they are, look, it's not the plaintiff who wanted that out. The plaintiff wanted all of the dependency stuff in. They wanted to show the report. They wanted to go through the report with her, but the defense kept it out because her report is full of lies and slander that they could prove. And now when it works in their favor, the defense wants to bring in Chapter 39.
Let me ask a kind of a bottom line question here first.
Hold on. Can I see the attorneys again?
Oh boy, judge wants him back. He's not going to let him go down this road. Because it wouldn't be fair. The plaintiffs weren't allowed to go down Chapter 39 and talk about the court case.
Hey, please go. Thank you, Your Honor. Going back to this exhibit, had you asked to meet with the treatment team at this point?
No, I was making that request in my role as the medical director for the child protection team to assist with that side of the situation.
Okay. Were you a member of the treatment team?
No, and I didn't attend this meeting.
Oh,
I'm
you
building a
wound up
laundry
not attending
fort.
this meeting.
I'm like
It wasn't for
Daryl
me
Brooks.
to be there. It was for them to have the discussion.
And you wanted to know what their consensus was. Well, I mean, strike that. Never mind.
He doesn't want the jury to hear that. Did you hear that?
Strike that. Never mind.
Listen.
You wanted to know.
Them to have the discussion.
Listen to
Attending
this.
this meeting.
And I didn't attend this meeting.
I didn't attend this
You
meeting.
wound up not attending this meeting.
It wasn't for me to be there. It was for them to have the discussion.
And you wanted to know what their consensus was. Well, I mean, strike that. Never mind.
He doesn't want to create the impression of what the truth is. And the truth is that she was directing this team. She was the one directing the team. And he almost went there. Oh, you wanted to know what their consensus was, though. You were keeping up on this. He got thrown by that. He realized what he did. And now he doesn't know what to say. And I think he also knows that she lied on the stand about being at the meeting, and that threw him, because you're going to find out later that she was at the meeting. So he was expecting to ask her questions about the meeting. And then he can't remind her on the stand that she was actually there. If she testifies that she wasn't there, he can't go on and ask the rest of his questions that he expected to ask her. And he's like, oh, shit. Listen to this long pause.
Did there come a point at which you became aware of any pictures or videos being taken of Maya?
Yes.
And tell us in general how that came about.
I'm not sure from the standpoint of the treating team at the hospital. From my standpoint, that was related to attempting to have some photo documentation as part of my evaluation, and that could be available as part of the investigation.
Was it your understanding, well, did you have any understanding of whether the treatment team desired any such pictures for clinical reasons?
I believe so, but what I can speak to is what I was doing with, or my role with it, and my role was related to this attempt for some, in this case, video documentation for the purposes of the investigation.
So was there ever any point during this patient's entire hospitalization at which you were part of the treatment of the team rendering clinical care to Maya Kowalski?
No.
Bullshit.
And did you ever hold yourself out as such?
No.
To the
Bullshit.
parents?
No.
You were directing the team.
That's all I have for now, Your Honor.
All right, here comes Cross. Frankly, I've seen some of this, and he did not go nearly hard enough on her, because you're going to find out in the proffer that he really goes hard on her in the proffer. I don't know why he didn't do it in front of the jury, but he came out swinging in that proffer, and she cracked. She looked like hell. She looked terrible. She cracked. She lost her temper. She yelled. She fought back, and it looked really bad. She didn't do that in front of the jury, though. So I don't know why he didn't come out swinging harder. She keeps her cool in front of the jury. I don't know if they noticed Valor Warrior, but I do know they're going to find out real soon that she just lied on the stand. And maybe they'll
Dr.
believe
Smith,
her that she just
how many times have you testified in court?
Probably over 300.
And how often have you met?
That's over 300 families that this woman has accused of child abuse in one freaking county. Are you kidding me? That's sick.
With defense counsel.
Wait, let's back up. What was the question?
And how often have you met with defense counsel?
Well, pretty often, because usually there's a deposition in cases where I'm testifying. Oh, this one? 0.
You did not meet with Mr. Hunter
I did
yesterday?
not.
Did you have phone conversations with him?
I did not.
And not an email?
No.
In the week before, did you?
No.
How did you know to come here today?
Because my attorney from Suncoast Center's insurance company told me to.
Are you still doing what you were doing in 2016 to this day?
I'm a pediatrician. I resigned from the child protection team last July.
Thank God. But don't think that that doesn't stop her from doing what she's doing, because she'll pick up that phone and call the next county child abuse team leader to do what she does.
You wear several hats, Fifth Avenue Pediatrics, private pediatric practice, right?
Yes.
And then back in 2016, you were more or less director of the Johns Hopkins child abuse team, right?
They don't have a team. They had residents that came to our clinic to learn about child abuse pediatrics once or twice during their second year of training. And I was the designated director for that rotation for them. And if we had maybe 5 or so over the 20 years I was the medical director, residents who came and worked with us for a month, so I would be the person that would be supervising them for those rotations.
All right, so you're in charge of the residency and
for those things.
And so you were considered at this point by Dr. Tepa Sanchez as the go-to person for Johns Hopkins, insofar as the.
Yeah, she's the go-to person. It's not that hard to figure it out.
Doctors there.
Well, they wouldn't be saying that to me, so I'd have to say no. I don't know what they say amongst themselves.
Okay. Now you said though that you weren't a part of the treatment team. Did I understand your testimony?
I was not. Correct.
We bring up 1002-0005. Next to last paragraph, bottom sentence.
I'm sorry. Oh, okay. I see at the very top, barely see the discharge summary note. Okay.
All right.
Okay.
Now, you didn't have any training in psychiatry, right?
Just rotations in medical school and residency.
You were not a pediatric psychiatrist.
Certainly not.
You were not a pain specialist.
No.
You were not an anesthesiologist.
No.
You were not involved in rehabilitation medicine.
No.
But you were included nonetheless in this treatment team, were you not?
No.
Let's go to 002-0006. And let's look at the bottom paragraph, third line. I think it's the last of the second and top and third sentence. Nope. Above.
Dr. Sally Smith were all heavily involved in her care. Watch how she tries to weasel out of this one.
No. This is at 0006, and I'm looking for the. All right. So Dr. Sally Smith was heavily involved in her care. Is that true?
As the medical director for the child protection team in a complex medical child abuse case, yes, that's correct.
Well, you were involved in considerably more than that, were you not?
Not in any type of day-to-day treatment of the child, but certainly in a role coordinating some of the elements related to the investigation in the court case.
That's quite
getting Maya Kowalski off of all of her medications is not part of your job with CPT, is it?
Well, so that was,
isn't it? Yes or no?
Yes or no?
Excuse me, Honor.
Then she
Shut
says
up.
yes or no to whether it was or was not part of her
Why
job.
don't you answer the specific question? If you need to explain, you can start explaining.
I'm sorry, could you just state the question again one time?
Sure.
Sure.
Well, deciding what medications Maya Kowalski should be on or whether to take her off of medications is not part of your job description at child protection, is it? Or was it?
The
Is that
part
yes
about,
or no?
yes, but I have to explain.
Yes, it's part of your job to do that, to manage Maya Kowalski's medications.
Look at her face.
May I explain?
Well, yes.
So the part that was part of the question was related to taking her off medications. In cases of medical child abuse, one of the things that is important to try to do in a
Wait, Night Owl, you want me to rewind and read what to you? The document? What did you miss? Was it the document that you missed? I don't know. I don't know what you missed. You're going to have to tell me.
controlled setting like a hospital is if a child is on medications that may not be necessary, that the treatment team would consider to wean those medications in that controlled setting.
All right, so were you part of the treatment team or not?
I guess it's sort of threading the needle.
And there it is. And there it is. Yeah, you were. Well, I guess it's sort of threading the needle. So in other words, you're trying to say you weren't, but you were calling all the shots. They were doing what you asked them to do. Joby, thanks so much for the Cash App for $25. I look forward to your coverage of this trial. Thank you so much. And Courtney, thanks for the $10. Thanks for covering this trial. I appreciate those very much. Thanks, guys.
I wasn't writing any orders. I didn't tell them which medications to stop or wean or anything like that. But as part of the whole evaluation of medical child abuse, there's a component of what happens when they aren't getting all these medications. And so that specific little part of it was within my role.
Exhibit 2116, please. Now, you just told them to get her off as many medications as possible. Down number 15, next to last from the bottom. I think there's a misspelling there, but we can agree.
I believe the legal
Is
term
that
is
a
read.
text from you? To
Yes, it is.
Paul
Yes, it is.
The Paul Dees that testified, well, you wouldn't know. Probably already, but is that as many meds? It just says meds here, but it's supposed to be meds as possible?
Yes, and her reply is the last one's going off today.
Okay. So were you or were you not advising the treatment team, as part of the treatment team, to take Maya Kowalski off of all of these medications?
I was assisting them from the standpoint of the medical child protection team, medical child abuse realm. And as the reply makes it clear, they were already doing it and I didn't even know they were. So certainly wasn't directing that process.
You didn't know what they were. Weren't you involved in Maya Kowalski's lab results as well?
I'm not sure what you're talking about.
Exhibit 1001-0317. On November 15th, 2016, with Dr. Pagan, as part of the child protection, the treatment team, did he consult with you about an extensive chart review and recommendations?
Oh, boy.
So again,
I'm just asking whether he did or didn't.
well, clearly, I believe I had some discussion with Dr. Carroll, who this is, she's one of the hospitalists. And so that's her
Dr.
note. So clearly
Pagan?
we had some discussion.
Wait a minute, I missed that. Yeah, he did say Dr. Pagan. What is going on in this case? Dr. Pagan? We've got the 7th floor coven, and now we find out that there's a doctor there named Dr. Pagan. This simulation does not disappoint. Does not disappoint in this case.
About documenting that certain lab tests presumably were now normal that had been abnormal, but I didn't order the tests or anything like that.
Are you saying that where it says in a progress note in the Johns Hopkins records, which you say you have access to, right?
Yes.
It says that the treatment team leader spoke at length with Dr. Sally Smith, you, right?
Yes.
That you had done an extensive chart review, right?
Yes.
And you were making recommendations regarding lab tests, right?
I was, from the standpoint.
And then they did those. So they, in other words, they do what you tell them to do. No, you didn't write the order. You told them to write the order, and then they did it. Not on their own observations, but on yours.
You were making observations of whether they were abnormal. Is that right?
I knew she had abnormal tests that I had seen in all of these medical records that I reviewed. But I have to look up and see. I don't really recall if these lab tests done in mid-November had any abnormalities.
A CBC, a CMP, a UA, a lipid panel ordered. Lipid panel is to check her cholesterol level, is it not?
Right. At one time, hers was 363, I believe, quite elevated at various points.
So now you're in charge of her cholesterol as well. Is that right?
The lab tests had certain abnormalities that, based on my record review, I suspected were related to medications and potential toxicity. And so in evaluating the medical child abuse, one of the things we're trying to assess is if harm has been done, and hopefully it's reversible. So that was the thought process, the mindset that I was approaching this discussion with Dr. Carroll.
You're not a pharmacologist, are you?
I'm not.
Also, an IG profile. What's an IG profile?
Immunoglobulin.
And an IgE?
So that's a specific one of the immunoglobulins. There are A, G, M, and E.
And a RAS test to check and see if she had allergies?
Correct. That was one of the things in the medical records that was said to cause some of her symptoms.
Are you
allergies? Guys, just so you know what you're missing over on Locals, this is the kind of stuff that's happening in the chat and it is cracking me up. GL Scott says, what I think of when I hear professional street clothes. That is how she described what she was wearing. She was, what were you wearing? Professional street clothes. Locals chat. So great. All right, let's hear what happens here with the allergy medicine. Let's go back a little bit.
Of the things in the medical records that was said to cause some of her symptoms.
Are you an endocrinologist or an allergy expert?
I see a lot of children with endocrinological and allergy problems in my general practice, and I saw a lot of them in my role at All Children's for 12 years, but I have neither board certified specialty.
You don't have a specialty in either one of those, do you?
I just said that, right?
And you were worried about her
that.
dog dander allergy, right?
Yes.
And dog dander allergy is clearly part of Munchausen by proxy, right?
It is.
Yes.
Her mother is making her allergic to the dog, isn't she? Oh, Anderson, that was a good one. I know the Locals memes, meganfox.locals.com. There's a live chat happening over there right now. You can watch the stream over there and participate in the chat. And if you want to sign up so that you can do that, because you do have to be a subscriber to be participating in the chat. You don't have to be a subscriber to just follow me there. But I have promo code Maya for a free month when you sign up right now at $5 a month. So go check it out. If you want to sign up for a year, the promo code is SQUATS, and you'll get 2 free months when you sign up for a full year. But if you're just doing monthly or you just want to check it out, you use promo code MAYA, MAYA, all caps, and you'll get that. It's a text chat, and you can put GIFs, you can put memes, you can share photos. It's really fun. It's a fun chat.
May I continue?
No, I was just sustaining that objection.
All right.
And obviously there are memes over there that I cannot share here, but they're funny. Trust me.
On December 13th, 2016, and I realize you might not recognize a lot of the dates, but to put it in context, by December 13th, 2016, now Maya had been at the hospital for what, almost 3 months?
October 17th to December 13th would be a little over 2 months, right?
Right. And you were still on the team, were you not?
I was still the medical director of the child protection team.
Well, you were part of the treatment team, were you not?
I was not.
1001-0200.
They coached her to smile because she never smiled once in her deposition. They coached her hard. They told her, do not get testy, don't frown at him. And they coached her to do that. And it makes her a better witness than her deposition. I hate to say it, but it does. I don't think the jury's buying it, but.
Did you or did you not confer with the team
Oh my God.
regarding creating a behavior?
Wait, we'll back up in a second. Night Owl, she wants to take away Maya's dog. Oh my God, she really is the Wicked Witch of the West. And your little dog, too. Can't you just see it? I'll get you, my pretty. And your little dog, too.
With the team.
Let's go back.
Did you or did you not confer with the team regarding creating a behavior chart? Bottom last 2 sentences. Highlight, please.
Yep.
So,
did you or did you not become involved in creating a behavior chart for Maya Kowalski?
Looking at this note, I think I misspoke earlier. The way that I didn't see any of these ahead of time. But the way the email was written, it was that they should meet, but it looks like I probably did actually attend that team meeting. And so it looks like these were the things that were discussed.
Why does it sound so bad? Holy cow.
Related to coming up with this list of
so
things
loud.
that would potentially help
Sorry, guys.
the court that was involved at the time.
That was law and crime, not me.
You just said you hadn't seen these prior to this. Why would it be seen these?
Did we just get to the I
help
misspoke?
Coming up with this were discussed related to coming up with this list of things that would potentially help the court that was involved at the time.
You just said you hadn't seen these prior to this. Why would it be important for you to see all of these notes in the medical record prior to this, if all you're here to do is tell the truth about what you know?
Objection, Your Honor. Argument is sustained.
So we just learned she was at that meeting. She misspoke before, she says, or she lied on the stand. It's up to the jury to decide what they believe. Did she misspeak or did she lie?
And then you had the pain team on documenting pain weekly. Is that right?
Well, I mean, it speaks for itself. These were the things that they said we talked about. I don't have an independent recollection of this specific meeting. And certainly I've been reviewing a lot of stuff the last couple of weeks, but I did not see this nor Kathy Beatty's email ahead of time. So, I'm just going by what I'm seeing right here at the moment.
Okay, so then you were involved in changing the room?
Yeah, I'm not really sure what that's in reference to.
Was that changing the room to the 48-hour room, the surveillance room?
No, that was back in November. So
I'm sorry. Go ahead.
I was gonna say, I'm not sure what this is talking about.
Okay. So were you aware that during that 48 hours, Maya Kowalski was forced to urinate and defecate on herself because she could not get over to the commode?
Objection, argumentative, and facts on notice. Overruled. She can answer.
No.
Were you part of the decision to put the commode just out of reach of her so that she could not get to it herself and had to rely on a nurse?
Absolutely not.
Were you part of any decisions to make sure that the nurses?
Hold on, I don't think I believe that. That response was so condescending.
The commode just out of reach of her so that she could not get to it herself and had to rely on a nurse?
Absolutely not.
Were you part of any decisions to make sure that the nurses moved slowly so that she would be forced to have the decision of either urinating on herself or worse? or I guess calling and waiting?
No, I had no idea about that or what you're talking about.
Would that be challenging?
I don't believe you. You sit on a throne of
fly.
Stretch. Sustain.
All right. So, if we go back then, as you were talking about, that was in December. If we go back then into October, were you again part of the treatment team with Dr. Hart, Dr. Elliott, and Dr. Dees?
No.
1001-0429, please. Right above the line there, please. And the
Wait. Hangry Fox is home, and I want to hear how his thing went. How did it go?
So it went well,
Yeah.
and it was really funny because my dad was blinking at me like.
He was blinking at you. Was it good to see Dad there
Yeah.
in church?
Because, and then I was like this in the air, and he did it.
Yeah, you did. Did you get through the prayer okay?
I did.
Yeah.
And do you know what's awesome tomorrow?
What?
You can dress up whatever you want.
You can dress up tomorrow? It's not Halloween day tomorrow.
I know, but we can dress up whatever we like.
is
We
that
don't
the-
have to wear our uniforms.
Oh,
today.
it's casual dress tomorrow?
No casual. We can wear anything we want.
I don't know what that means. I'm gonna have to ask.
Like we can wear jammies. We can wear.
Oh, jammies.
I'm gonna wear jammies.
All right, go put your retainer in, okay? Honey, retainer.
Michael Jordan. I gotta wear
Can-
Michael Jordan.
Can you put your retainer in, please?
Okay.
All right. Thank you. All right. Sorry about that, guys. I just thought you would like to hear about that. So he prayed the memorare after the living rosary that they did today in church, and Mr. Fox got to go and see because I was taking my oldest daughter for her road test, which we won't find out how it went until 6 p.m. tonight. So we're nervous about it. All right, here we go.
that right there. Now, please take a look at it. Read it if you can.
Yes, I have.
All right. And here, Dr. Dees states that she spoke to you along with Dr. Hart and Dr. Elliott. Do you see that?
Yes, I'm pretty sure this is in reference to a meeting that we had on this, I think it was that day on October 18th. One of the things that's recommended in evaluating medical child abuse is to meet with the treating physicians and discuss what their observations are and everything so that I can then convey that in my report that I wasn't just sort of like out there rogue making this diagnosis, that there were other physicians with some of these other areas of expertise that I had discussed the case with and had the opportunity to hear their expert opinions. So Dr. Hart was the rehab physician, Dr. Elliott was the anesthesiologist, and Dr. Dees looks like would have been the hospitalist. It was the general pediatrician taking care of her at that time. So that was the purpose of that meeting.
Well, it says here that the purpose, the first one was continue with the current plan, right?
I don't think that's what it says. I think those are two separate things.
All right. Well, wouldn't a treatment team be the team deciding about keeping with the current plan?
Yes, and I think that's what Dr. Dees was referencing. So this is her brief note at the end of the pediatric residence note, and they will put in a few sentences, sometimes more. And so I think there are three separate sentences here where two separate sentences that she added to, convey what her plan was for that day as the attending physician.
All right. I was just simply asking you whether you were part here of a note in which the current plan described there was discussed.
I understand, I think, what you were asking, and I'm answering the question to the best of my ability.
Okay. You're aware that on October 8th of 2016, there was no active state investigation of the Kowalskis.
Not sure exactly when the report was made, but I think at least part of the day on the 8th, that is correct. It was either late that day or the following morning. I found out about the case the following morning. So the 9th. Yes.
Wait, guys, what did I
So-
miss? You're asking me, did I hear that? Did I hear what? What? Love into limes. What did I miss? What did I miss? Did I miss something? What? I'll back up a bit. I don't think I missed anything. They're just talking about, oh, if it was child abuse. If
that
it was child abuse.
There was no active state investigation
All right, we'll back up.
described there.
I
I
was
was just
reading your
simply asking
comments.
you whether you were part here.
I'm sorry, 2 separate sentences that she added, sometimes more. And so I think there are 3
Yeah, how many
separate
seconds ago?
sentences here where I'm sorry, 2 separate sentences that she added to, convey what her plan was for that day as the attending physician.
I was just simply asking you whether you were part here of a note in which the current plan described there was discussed.
I understand, I think, what you were asking, and I'm answering the question to the best of my ability.
Okay. You're aware that on October 8th of 2016, there was no active state investigation of the Kowalskis.
Not sure exactly when the report was made, but I think at least part of the day on the 8th, that is correct. It was either late that day or the following morning. I found out about the case the following morning. So the 9th. Yes.
So what were you doing accessing Maya Kowalski's private confidential medical records on the 8th if you were just part of the child protection team and there was no investigation?
I was doing so under HIPAA's what's called TPO exception to the confidentiality guidelines, which allows for
Objection, move to strike for legal conclusion as to what the statute says.
Her blue eyeshadow was a mistake. I don't think you should wear blue eyeshadow past 1985, but maybe that's just me. I mean, unless you're going for a costume party, perhaps. I mean, I guess there's a way to probably wear it, but I don't think this is it. Does she always match her eyeshadow with her blouse? It's kind of a strange look, but at least she is wearing, I think they told her to wear makeup because in those deposition videos, she wasn't wearing any, and they're trying to soften her look, but I probably would have picked pink and soft browns for her, not harsh blue. I think it just makes her look older and it's not good. Pink is a softening color. What's going on with the bailiff? Why is he over there?
I'm going to sustain the objection, Mr. Anderson. You can re-ask the question, and we'll get to a break in just a couple minutes. Mr. Anderson, within 5 minutes, we need to take a break.
So true or false, you accessed Maya Kowalski's medical records on the 8th.
I did.
Prior to that, you did not contact Jack or Beata Kowalski. True or false?
Correct.
Is it not true that you often walk in after?
Mr. Anderson, if you're going to a different,
I am.
Then why don't we take a break now? Members of the jury, do not discuss this case amongst yourselves. Do not do the investigation and receive more information.
All right, so taking a break. Let's skip forward. For those of you who are just getting here, obviously I am rewatching this from earlier because I was not able to watch live. I was not able to stream this live, so we are catching up here. So this is today's court trial, but it was from earlier this morning because I was doing family stuff. And we are watching it at 1.25 speed.
Great. And then how about O'Leary Johnson?
That's correct.
Great. Do we know where Mr. Hunter is? Or?
You want me to find him, John?
Hunter's not here.
Yes, sir.
Mr. Hunter's not here.
Conversation that we need Mr. Hunter for?
I only wanted to mark what the doctor brought in.
Why don't we wait for Mr. Hunter at that?
Yes, sir.
All right, Hunter is absent. Waiting for him to come back.
Carol and I have no relationship or just leave it alone?
I think they're clueless about that.
It's up to you, Judge. I mean, I don't.
I'm sorry. And as a
Okay.
reminder, my brother is.
Love into Limes. He asked her if what was child abuse. You're not telling me what. What is the thing that you heard that you think I missed? He asked her if what was child abuse. What is the thing that he accused her of, or that he asked her, is this child abuse? I need to know what the thing is that you're saying.
Is a Dr. Carroll. Yes. And so
It might be a good idea to just say something just for that reason. Yeah, because they may have heard Dr. Carroll.
I don't think it hurts.
So I'll just make that mention. Now, Mr. Anderson, there was another issue you wish to address with Mr. Hunter was here.
Oh, yes. Thank you, Judge. All I want to do was mark for identification what Dr. Smith brought in with her to testify with.
You mean all those notebooks?
Well, that's a good point.
And of course, see what we're talking about here.
Let's just talk practical from the clerk's perspective.
He asked if placing a commode out of reach and not answering calls for help to the point where Maya was defecating on herself qualifies as child abuse. And she said it was a stretch. I did see that the first time and I missed it this time because I was reading her comments. And yeah, I don't think the jury is going to like that very much. But then later in the testimony, she claims she never heard anything about this and she doesn't think it happened. That, unbelievable. Unbelievable. But yes, thank you for pointing that out.
If Dr. Sally Smith has only looked at like 2 pages this whole time.
Yes, I see the court's.
I have no, I mean, you mark that.
Yeah, I just think of the binder she has open right now is the only thing I would want. That's the only thing I've seen come out of it is this one binder that is before her right now.
Well, I don't think she's looked through the binder. I think she's only looked at a couple pages in her hand. So
I don't have any issue with her looking at her, with marking what she has looked at, but that should be it.
I always thought when they brought stuff to the stand, you could explore whatever they brought.
Well, if she's not looking at it, and it's just more or less a prop, if you will, at this point, I just don't want to have 5 or 6 5-inch notebooks having to be given to the clerk who already has so many notebooks.
She's got a notebook.
Yes, that's what I was just suggesting. Only this one that she has got open right now and referred to. I have not been able to see how many pages, what she's referred to, but I do know that it appears to only be one notebook.
Dr. Smith, why don't you close the black notebook and only keep out what you actually looked at, which is in your left hand.
Okay.
Okay. So as a reminder, if Dr. Smith is going to look at any of those items, then we'll probably mark that. But just to mark 5 binders, mark them, let's not do that.
Understood.
I don't know if it's proper, but all of these are shared documents that are date stamped, except for a couple of folders with references. And as you have stated, I haven't touched them. So
And unless and until you have to look at them, let's not worry about it, because I don't want to spend the time having the lawyers go through to check and make sure that there isn't a sheet of paper that isn't in evidence or not in evidence.
Right.
That would take forever and doesn't help us along.
Right.
What she's got is her report material.
Exactly. I didn't realize I wasn't going to need it.
And so I guess the moral of the story is unless you absolutely need to look at one of those items in your binder, let's not go there, because then
You got it.
adding tonnage to the number of items.
I was wondering why she brought all the binders.
Are we ready to bring in?
R.I.P. Fort Brooks.
Mr. Hunter, are you ready for the jury? Let's bring them in.
Oh, I made in case you missed my my Brooks reference earlier, I made a there she is behind Fort Brooks. She made her own fortress of binders, which were unnecessary and unneeded. And I was wondering, I guess that kind of though bolsters the idea that she did not talk to defense attorneys before this, because they would have told her not to bring all those binders, I would think.
Have you seen any media accounts since you were last with us? Has anyone approached you about this case since you were last with us? Mr. Anderson, you may continue. Before I did it, there's been a couple of references to Dr. Leslie Carroll. Obviously, my name.
Oh, wait, hold on. Okay, but you guys aren't believing that she doesn't know not to bring her notes. No, let me tell you why she doesn't know. You said she's testified 300 times? Come on. Oh, no, she's testified in kangaroo court, not real court. Kangaroo court, family court. Well, sometimes she's testified in criminal trials because she put that one guy in jail who's protesting outside. So it's possible though that the majority of her court experience has been in family court, and she can do whatever she wants there. There's no rules there. There's no rules. Very few rules apply to court actors like her. She's basically a prosecutor in that court. She can do whatever she wants. She can bring all her fraudulent lying reports and read from them, and that's all they do in those hearings for dependency hearings.
Last name is Carroll. There's no family relationship between Dr. Leslie Carroll and myself.
Look at her practicing her
redirect my
smile.
appeals to the various questions.
Well, it goes back to Mr. Hunter now.
What? It goes back to Mr. Hunter? Oh, right, for redirect.
Please go ahead. Counsel asked you about your access to the medical records when Dr. Sanchez called you.
Yes.
Was that as a result of your being asked to consult on a case by a fellow medical staff member?
Correct.
Is that customary, typical?
Yes, and
Objection, foundation, and predicate for that.
Well, the answer yes remains.
Your duties as the medical director of the child protection team, the CPT, if we can.
Yes.
Usually that's the shorthand folks usually use.
That's the usual. Yes.
Okay. Is part of your, do you understand part of your statutory duties with the CPT to follow patients who are sheltered under a child abuse investigation?
My understanding of my responsibility is to provide whatever assistance is requested from the investigators, law enforcement, and attorneys that are involved in the case.
Get closer to the microphone, lady.
I think I'll leave it there.
Okay. And I think I better leave it there. Have we ever spoken?
I believe, I might be wrong, I believe you were at one of my 5 depositions, but other than that, I knew of you when I worked at the hospital, but otherwise, no, to my recollection, no.
Have we ever discussed this case?
No.
You ever discussed this case with anyone from my office?
No.
Nothing further, Your Honor.
Mr. Anderson, anything further?
No, Your Honor.
Members of the jury.
All right, jury questions. Bring on the jury. All right. Resting witch face. That's funny. Resting witch face. RWF. Oh, that's funny. All right. Jury questions. Here they come. The jury is handing the questions to the bailiff. I'm doing my recovery addict impression. All right. So this was a really long sidebar. You can listen to recovery addict reading this sidebar. Well, not reading. He's repeating it because he's listening in on the Zoom. So if you go back to his earlier stream today, you can actually hear this whole conversation, and it is interesting. At one point, Hunter gets really pissed off because he says one of the questions, and it was a really pedestrian question. Hunter claimed that the question, one of the jurors wants to know how many children were taken from parents in Pinellas County. And I don't know if they gave a time frame or not on that question, but they basically want to know how many of those cases were you involved in? They wanted to know how many cases that Sally Smith has been involved in taking kids from families. Hunter goes crazy and he's like, that question is terrifying, Your Honor. That means that's the entire thing that the Netflix documentary was based on. That's the entire premise of the Netflix documentary. And that makes me believe that this jury did its own research. And he's wrong, first of all, because there are plenty, and the judge calls him out on it. There are plenty of times. He said, there's been plenty of times over I'm going to stop sharing this for a second. Hopefully my camera will catch up in the meantime. It's like when I'm sharing another page that it does that. So Hunter says he's all upset because the jury, he thinks, has done research in order to ask that question. And Judge Carroll tells him, I've seen many articles over many years ago about this particular problem. And he's specifying the, CPS taking kids wrongfully from families. And he's right. Those of us in the media who have covered these stories have been telling them for years. I've been doing it for 20 years. I've been, harping on the inequalities and the injustice in the child protective services realm for 20 years. So it's not fair to say, oh, this jury did extra research. There's no way they would know that this is a problem. Maybe they just want to know. Like, yeah, how many kids have you taken? It's a perfectly reasonable question. However, as far as I know, the question, I didn't hear the question get asked, but I wasn't paying total attention when I heard this part because I was helping my daughter. We were driving down to the driving test or whatever. So I didn't hear everything. I don't think that question actually gets asked. So I think that his whatever his objection to it was got sustained. However, the judge did shoot down the idea that the jury was doing any research outside. Oh, and he also said, Anderson said, we have at least one nurse on the jury who would know these things, right? Yeah, and it's really the witness's fault because the witness said she did 300 court appearances. That is automatically going to make those people on the jury go, well, how many kids did you take from their parents? How many of those kids did the parents lose custody? You know what? That would have been a better question. I wish they had said, you testified that you were testifying in 300 cases at least. In how many of those cases did parents lose custody of their kids? That probably would have gotten through the objection because it was the witness's own testimony that opened that door. But I think they would have had to fight for that based on her testimony alone. And they didn't. They didn't. Oh yeah, the jury should have asked why she resigned. Yeah, I don't know if they didn't though, as far as I know. So anyway, if you want to go back and hear all of the what the arguing about the questions, you can do that on Recovery Addict stream from earlier this morning because he does repeat what they are saying from the Zoom call, and it's great the way he does it, like a sportscaster. I swear, it's hilarious. He does a great job at it. His voice is very pleasant to listen to. Okay, there's still sidebarring. Let's move forward. This took forever. Jack looks pissed, as I'm sure it's very hard to be confronted by this person and be in the same room with her. Testicular trauma, you're asking how many didn't have the ability to speak up? And of those families, hardly any of them. They don't have any money. They're bankrupted by the process in the first place. They don't have access to lawyers. Yeah, Jules, 300 families could mean 3 kids per family. 2.5 average American families have 2.5 average kids. It could be 600 children. It could be 1,000 children, depending on how many kids.
Presence of the jury. Have you had a conversation with a nurse, Bonnie Rice from Tampa General Hospital?
Back in the time of this case, yes.
When was that conversation, to the best of your recollection? A month and a year is fine for the purpose of this question.
I would say October into November, late October, early November 2016.
Was there any conversations, to the best of your recollection, between you and Bonnie Rice in calendar year 2015 about Maya Kowalski?
No.
Okay. I'm going to ask you those 2 questions first, and then I'm going to ask you the rest of the jury questions.
Okay.
Let's bring in the jury.
Suzanne, I missed your Venmo yesterday. Thank you so much for that, for the $10 Venmo. I appreciate that. And also, Tara, I missed yours as well yesterday. You were laughing about St. Lisa of the laundry, the laundress. She was funny.
Investigation received no
Yesterday was a
information.
fun day.
That you haven't seen any media reports of this case. Is that correct? Correct. No one approached you. Is that correct? Outside of Dr. Smith's presence, I went through the jury's questions. I'm going to be able to ask a good number of them, but not all of them. Dr. Smith, have you had a conversation with a nurse, Bonnie Rice, from Tampa General Hospital in connection with Mike Kowalski?
She's a nurse practitioner, but yes.
When approximately was that conversation?
I'm pretty sure it was in late October, early November of 2016.
Have you had any conversations with nurse practitioner Rice in calendar year 2015 with respect to Mike Kowalski?
No.
Next question. Do you know why it is the hospital's policy to contact you first instead of reporting the suspected abuse to the child abuse hotline?
It's an unusual situation. And because of the way that the whole system is set up in Florida and they have to file a report for me to do a medical evaluation, sometimes they're not sure what to do. And so in those occasional situations, I'm going to say once or twice a year, a doctor from All Children's would call me to ask me a question about the case that they were involved in and request my expertise related to the child abuse and neglect question.
They would request your interference in a case that hasn't even been opened yet. They ask you to come. What they're asking for is for you to come in and gin up some evidence so that they can have evidence to make the phone call, because they don't have evidence to make the call, or they wouldn't have called you. They would have called the hotline.
Correct me if I am wrong. There is no harm in contacting the hotline prior to contacting an expert first.
Oh boy, the jury's figured it out. The jury's figured it out. At least somebody on the jury's figured it out. They're like, wait a minute. Where's the harm in calling the hotline and going through the rules, following the rules? Where's the harm in that? Is there any harm in calling the hotline first instead of you? Look at the eyes.
I'm sorry, can you?
Sure.
Holy shit. That wasn't a hard question.
Neglect question.
That wasn't a hard question. Look at her eyes.
Correct me if I am wrong.
Watch this.
There is no harm in contacting the hotline prior to contacting an expert first.
I'm sorry, can you?
Sure. Correct me if I am wrong. There is no harm in contacting the hotline prior to contacting an expert first.
There is no harm.
The only situation would be if there potentially wasn't really enough evidence or whatever.
Wait, this is it. This is it. She just, and she knows the second she started to say this, she knows she shouldn't say it. She knows she shouldn't say it. Watch this. She knows it shouldn't come out of her mouth.
Would be the only situation would be if there potentially wasn't really enough evidence or whatever to justify a report.
Evidence or whatever. You know that evidence or whatever? You know that thing that we rely on to convict people? You know that evidence or whatever. She really didn't want to say evidence, but it came out. There it is. There it is. There wasn't enough evidence to make the call to the hotline. So they called in the ringer. They called in the expert who would make sure she fabricated enough evidence that they could make the call. So the call wasn't justified. How the fuck did this judge make a call that the hospital had good faith to make that phone call? How did he make that call and get them immunity for making the call in the first place? Because now we have evidence, a testimony on the stand that there wasn't enough evidence or whatever to make the call. Well, then the call should never have happened. You shouldn't have been involved, and this whole thing should have been thrown out. And Chapter 39 be damned, the hospital should be on the hook for making the call, because now we know there wasn't enough evidence to make the call. There wasn't enough evidence to make the call. Let's hear that one more time. Rage activated is right. Rage activated. Let's hear it again. Why didn't you do the thing according to the law that you were supposed to do? Well, there wasn't enough evidence or whatever. So I had to come in and gin some up. I had to come in and make it up.
The hotline prior to contacting.
Let's hear the whole question.
I'm sorry, can you?
Sure. Correct me if I am wrong. There is no harm in contacting the hotline prior to contacting an expert first.
The only situation would be if there potentially wasn't really enough evidence or whatever to justify a report. So otherwise, no, I mean, typically the report gets made before I, as an expert, would be involved. Almost all the time.
Almost all the time, unless there isn't enough evidence to make the call. I'm sorry, but I think that's the most damning evidence to come out of this trial. There wasn't enough evidence. There wasn't enough evidence. But you came in and suddenly there was enough evidence to make the call. Curiouser and curiouser.
How would CPT normally access the medical records?
So I always would access them through my remote access that's granted as a member of the active medical staff. If it was a child protection team, say from Sarasota County, that the person didn't have privileges at All Children's, then what they would have to do would be to, submit a request for the records to the hospital to obtain those records.
Holy shit, did you just hear that? So because of her special privileges at Johns Hopkins that she's not affiliated with in any way, she was able to bypass the actual standard operation, which is that DCF has to make a phone call to the hospital to request access to those records. And the people they would be calling, let's think about this, the people that they would be calling would not be Dr. Pepper, would not be Dr. Pagan, would not be Dr. whoever on the 7th floor witches coven. It would be some other office that deals with it, and they would look at it and go, there's really not enough evidence here. There's not for us to violate HIPAA and give you the records. So go get a court order. She skipped all over the steps, but she could go in there without a court order. She could go in there without hospital permission and build a case against a family with no lawful authority to do so. And that's what she did.
Does the county child protection team have access to medical records normally without privileges?
Nope.
Only because, well, not like I do with it's an electronic access.
Nope, they don't. I have it because I'm special because I am connected to Johns Hopkins.
Another team or somebody besides me would have to make that request. And there's statutory language that requires the hospital to provide those records in the furtherance of the investigation. So they can get them, but they can't just log in and,
but you can
and see them as easily as I can.
You just think you don't need, she thinks she doesn't need to go through the steps because they're required to provide them. So they were going to provide them anyway if we asked for them. So I didn't need to ask because I already have the record. I've got authorization. I can do whatever the hell I want. I don't have to follow statutory requirements. I can do whatever I want.
Part of the child protection team required to have privileges at a hospital to provide a medical assessment.
I'm pretty sure that is correct. So mine's easy because they're just in one hospital. Other teams, like say, for example, in Miami, I think the medical director probably has to have privileges at Jackson Memorial and Miami Children's in order to go in and see the child. But I'm honestly not sure because it's not my situation. So I don't know exactly what the rule is with that. I think probably they have to have privileges, but I'm not sure.
So if yes, do the privileges grant access to the patient's medical records?
Yes. So as part of our credentialing, we get re-credentialed every 2 years. We have to do like certain, HIPAA training about medical records. There are rules about which ones you can and can't access. And it's pretty closely watched and monitored. And so, I can do that in my role as the medical director of the child protection team. And on these occasional situations where they call me separately because they're not sure what to do and need child abuse.
Where is that written? Where is it written that that's the policy, that on occasional Occasionally, when they don't know what to do, I'm allowed to access records before I have a court order or before I have permission from DCF. Chaos Coordinator, thanks for the super chat, says the jury is in a get wrecked J-hatch mode. Yeah, I think they are. And it's great to see. It's great to say. Great to see.
Expertise. I can do it in that role as a member of the medical staff.
Is it standard for a child protection team physician to offer recommendation to a child's treating physician in a suspected child abuse case?
With regards to potentially certain tests or certain needs of the court, yeah. So for example, if I'm seeing a child that has a bunch of injuries and they need a follow-up brain scan, I can make that recommendation to the team. Could you please do a brain scan on such and such date? And, typically they're going to do what I ask them to do in terms of that, because it's something I need for the purposes of the investigation and to assist all the various people involved.
But you're not allowed to get that. Hold on. You're not allowed to get that until there is an investigation ongoing. She accessed the records before the phone call was made to DCF. She accessed records in violation of her training. Twisted Puppet says she accessed all of the records she was not allowed to access. I've taken that HIPAA training too, and I know full well what she did is a direct violation. It's a real shit show. It really is. And I got to tell you, I don't think Anderson hit on this stuff like we are. I don't know what happened with him, but I don't like how this went. He didn't do the follow-up like I would have, but maybe he's just figuring that the jury already has her number.
I think that answers probably.
Who made the referral to your child protection team for the evaluation?
The child protective investigator called our person called a case coordinator that was on call or was the designated person to receive what they call intakes. So when there's an investigation that's been initiated, particularly in a case like this where there's a major medical component, then the child protective investigator calls the child protection team, and one of these case coordinators, or we actually had a person that they called an intake coordinator, takes the information, kind of reviews everything.
But you didn't do any of this.
That person would contact me and say, Dr. Smith, we need you to go down and see such and such child.
But you didn't do any of that. Didn't happen here. You started the investigation before anybody asked you to do shit. None of that happened.
When you told Dr. Dees to get Maya off as many meds as possible, did you know?
The jury's already accepted the premise that she told Dr. Dees to take her off medicine. Did you hear that? When you told Dr. Dees to take Maya off all her medications, so they already believe that that's what happened. That's what you got to know about that question right there.
To get Maya off as many meds as possible. Did you know that was already in progress prior to telling Dr. Dees to do so?
I did not.
Lips disappearing.
Do you still have medical privileges at Johns Hopkins All Children's Hospital?
Yes, I still have active medical staff.
Oh my God, she's still on
Members of the jury, that is all the questions that I'm going to be able to ask. So, Mr. Hunter, you now have the floor, sir.
He didn't get to ask the question about how many kids have you stolen. It's so unfair. And I wish they had asked, have you ever been accused of false allegations of child abuse before, and how many times? Or have you ever been, have any of your cases been found in a court of law to have been unnecessary and unfounded? All of that, I wish they had asked.
Can I have trial exhibit 2408-1739 in evidence?
Sorry about the pounding sounds. It sounds like somebody is doing hammering or something. It could be Mr. Fox, or it could be Hangry Fox. He could be doing some kind of woodworking. Oh my God, Lisa! Lisa, she's wearing the stolen host on her charm necklace. It does look like it could hold a wafer. It does. That's funny. That's really funny. I hear hammering. It could just be. I'm glad you don't hear it, but I hear it.
Okay, you lost me again. This is for your edification, Doctor, this is an email from Beata Kowalski dated 12 October 2016. And I'm going to ask that you go to page 1739, the following page. And then
These are the emails from
midway
Beata to
through
Beata.
the second full paragraph on that page, there's a indications Tuesday 10/11 evening. I had another supersized visit from MD Dr. Smith, who was sent by CPS to investigate this case. Would that have been about the time that you spoke with Mrs. Kowalski, the author of this email?
Yes, that's exactly what, and she says an hour and a half. So just like I said earlier, that was that evening that I came down and talked with her.
Okay.
Yeah, is it
there was
possible,
reference-
however, that she looked you up after that conversation? I don't think she knew when you walked into the room and said you were part of the child protection team that she knew you were with CPS until after that call. I mean, after that conversation, because I know most people would go and look that doctor up if you suddenly are thrown into, oh my God, now we're being investigated. So it would not surprise me if Beata then went and looked her up and wrote about it in her journal and figured it out.
To the EEG
Because
video.
Beata was smart. Is it dated? Yeah, it's the same day that she had the meeting with her. The same day. But, Google is a thing.
That was taken to this patient?
Yes.
Have you ever reviewed it?
I don't believe so. It's possible at the time I looked at a few minutes of it, but I don't think so.
Were you aware of any indication on that video of Maya Kowalski defecating or urinating upon herself?
But she just said that she didn't review the video. How can you say, are you aware on that video that she wet herself?
I had no idea if that was true.
She
or not,
didn't
frankly.
watch it.
Did you ever hear any indication of that and
No.
suggestion of that in real time?
No.
That's all I have. Thank you.
Mr. Anderson.
Yes.
FFS, for fuck's sake, says 301 county sounds excessive, and that's just her. Yeah, it is excessive, and CPS is excessive. DCF is excessive. Their entire modus operandi is excessiveness. They are Health and Human Services does a yearly review. Last time I looked it up, 80% of all child abuse investigations are unfounded.
Mr. Hunter, you have the floor.
Unfounded. But that does not mean that you get your kids back. It's a racket, folks. That means 80% of the people that they investigate did not deserve to be investigated. 80%. I'll show you those stats one day. I researched it extensively for articles that I've written, and that number is sadly true.
Oh, Madam Court Reporter, if you could mark this transcript as the proffer.
Thank you, Your Honor.
You got to ask yourself, if 80% of the work you do was unnecessary, do we need this? Do we need you doing your work? Do our tax dollars need to go to fund an organization that 80% of what it does is deemed unnecessary? Yeah, and that's another thing. Testicular trauma says, remember, Megan, that information remains on a file. That file never goes away. You automatically have a history with DCF, even if there's no history. That's right. And then what happens to you is when Cindy Absug's case was unfounded in Broward County, the sheriff investigated and said unfounded because there were ridiculous charges brought against her from an angry ex. It didn't matter that it was unfounded. In Colorado, DCF saw it, it flagged in the record, and they used it against her anyway. And that's the way it works. And that stuff never comes out of your record, ever. Once you've been accused of child abuse and it goes in a DCF record, it's there for life. And every time, if you ever get flagged again, you're going down.
Smith, this is a proffer for a potential appellate record, and what I'm going to do is ask you some kind of conclusory questions and
all right,
some summary questions.
This is for the appellate record. It is a proffer. There is no jury in the room, and I'm disgusted by what goes on here. All of this, I believe, should have been allowed in front of the jury, and I am just pissed off that the jury didn't get to see this.
To avoid you're having to sit here for a long afternoon, and all of us the same way.
Okay.
In the process of your investigation of the Maya Kowalski case, after it was referred to you did you conduct an investigation? Did you gather some medical records?
I did a medical evaluation, including gathering a lot of medical records. Yes.
Okay. And did you, in fact, promulgate 2 different reports?
Yes.
Regarding that. One was a preliminary report in October of 2016.
October 13th, correct.
Okay. And the other was one signed December 2nd, 2016.
Correct.
Do those reports both indicate the results of your investigation and review to that date?
Yes.
Okay. And in connection with your report in your investigation, did you obtain certain medical records regarding Maya Kowalski?
Yes.
And does your report, does a report you signed December 2nd, 2016, fairly and accurately reflect the records that you gathered and then reviewed for your report?
Up until that time, yes.
Okay. And then were there subsequent records you reviewed after that, after you received after that date?
Yes.
Okay. And does your report first of October, I think you said 13th, 2016?
Correct. Yes.
Does it fairly and accurately reflect your conclusions up to that date?
Yes.
Okay. And that would, if we were to walk through that report and what it was based upon, would your indication be that it contained and fairly reflected the outcome and your conclusions of your investigation up to October 13th, 2016?
Yes.
And would it also reflect what you advised up to the conclusions and facts of which you advised the court, the dependency court, as of that date?
Yes.
Okay. I'm going to show you what we're going to mark as whatever the court clerk tells me we're going to mark it as.
What's the next in the series for the defendants?
3328.
For ID.
For ID, it's not coming into evidence.
Correct. This is 3328 for identification. Let me just ask you, is that a true and correct copy of your report of October 13th, 2016?
Yes.
Can you hand that to me? Are you finished with it, Mr. Hunter? Madam Clerk, it's 2-sided, so just be careful.
And then after you rendered that report of 2006, these are new lips, I'm sorry, October 13th, 2016, after you rendered that report, did you continue an investigation as reflected in the report that you signed on December 2nd, 2016?
I continued my medical evaluation up to that point in December and gathered lots of additional records beyond what I had on October 15th. Yes.
Okay. And I have a badly marked up copy of what I'm going to ask be marked for identification as defense exhibit.
Well, is there already a specific exhibit number on that? Down at the bottom, Mr. Hunter, the first page, look at the first page.
December or the October?
December.
December is 3045, 146.
The answer to your question, my copy doesn't, but I trust Mr.
Mr. Hughes, will you say that and let the clerk know what defense numbers are the 2 reports that have been previously marked?
So the first report is in October 13, 2016 preliminary report. It is defense exhibit number 3044. The
For ID, it's not in, it's just ID.
Just for identification purposes. For identification purposes, Sally Smith's December 5th, 2016 report is defense exhibits number 3045, and that's pages 1 through 46. It's currently being printed.
Or can't we just put the first
That's
page
fine.
up if you want?
That's fine. Okay. I apologize for that.
No worries. Thank you, Mr. Hughes.
And to the clerk for attempting to gum up the works one more time. Does your December 2nd, 2016 report, defense exhibit 3045, does it also reflect your opinions and conclusions as of that date regarding your investigation?
Regarding my medical evaluation, yes.
Okay. And just if you would briefly tell the court what your opinions were regarding this matter as reflected in that report.
As reflected in that report, it was my conclusion that there was what we call positive findings for medical child abuse, and that the medical record review and the history taking and that kind of thing that I had reviewed provided very strong evidence to support that conclusion.
Except the court found that it was all garbage because they let Maya go home. Now, if they really believed that she was in an abusive situation, and this woman accused Jack too, not just Beata. She accused them both. She said that Jack was a, I don't know, colluder or whatever in the child abuse. The court dropped it. They dropped the case. So yeah, she's sticking to her guns that Maya was abused.
Was there any conclusion, and is that the conclusion of medical child abuse would colloquially be known as Munchausen by proxy?
Yes, and I believe it's even in the what we call the
Garbage.
impression. That was my conclusion in the
That's
report.
garbage.
I put in parentheses Munchausen syndrome by proxy because that's kind of a well-known term for this situation.
Okay. And did you reach any conclusion regarding conversion disorder?
Yes.
And what was that?
It was my opinion based on all of the observations of the various medical staff and team and staff members, et cetera, as well as based on multiple other physicians' reports that I had reviewed that she had conversion disorder. It's actually called a functional neurological disorder now, but at that time it was called a conversion disorder.
When we say she, you refer to Maya Kowalski?
Maya Kowalski, yes.
Yeah, it's called a functional neurological
reaching the
disorder now.
conclusion-
Guess why? Guess why it's called a functional neurological disorder now? Because they used to believe that conversion disorder was a psychological disorder, and now they know that it's a neuro, what's the word I'm looking for? It is a brain problem. It is not in your head as a psychological disorder. And so they are conflating these two. This is how little she knows about factitious disorder or Munchausen. She thinks that conversion disorder is the thing your kid gets when you abuse them with medical child abuse. But that's not true. It is a brain disorder. And that you heard the defense's own expert witnesses testify that conversion disorder was previously thought to be a psychological disorder, but now is thought to be a brain disorder. So even if Maya has conversion disorder, it's neurological. Thank you, beginner crafter. I wasn't putting the other part of the word on there. I was like neuro, Bueller. It's a neurological disorder, which means it's a brain disorder. So if her mother got it wrong, or the doctors, not her mother, if her parents were seeking answers and the doctors they went to got it wrong, how is that abuse? It's not abuse. The kid is sick. There's no doubt she's sick, whether it's CRPS or conversion disorder. She's sick. She's in pain. So what? And that's not in dispute. It's not in dispute by this woman either. And she accused her mother of abuse for trying to seek help for a kid who's sick. Who cares what it is?
And opinions you've just expressed to us, how many pages of medical records did you review?
I don't know exactly as I sit here, but well over 2,000.
Okay. And I see you brought with you today a stack of 3, 4, and 5-inch binders that is on the table in front of you. Are those at least some of the records you reviewed?
Those are all the medical records that I printed. So there are some that I reviewed in the electronic medical record from Johns Hopkins All Children's Hospital that I don't have copies of. But everything that I had a copy of in terms of all her medical records going back to actually her first visit to the pediatrician up in Chicago is in those binders.
Okay. And did the material you reviewed also include certain online WordPress blogs that had been created by Beata Kowalski?
Yes.
I believe that's all I have, Your Honor.
Mr. Anderson, do you have anything in proffer?
Oh, yeah.
Dr. Smith.
Here it comes. Here it comes.
Or let's say, right at the start of this, in the first part of October, you had a call with Dr. Kirkpatrick, did you not?
I did.
And Dr. Kirkpatrick explained to you that he had been treating Maya Kowalski for CRPS, correct?
He did.
And he told you that statistically speaking, CRPS is often mistaken for conversion or Munchausen by proxy, did he not?
I don't really remember exactly what his words were. I took a few notes from the conversation that I had with him, and I know that there was some general discussion along those lines.
And yet you did not put anything in your report about Dr. Kirkpatrick, did you?
Yes, I believe there's a whole section about his medical records.
Yeah, except for the fact that you did not tell anyone in that report that he had warned you off of going after the Kowalskis.
It's completely irrelevant for a child protection team medical evaluation.
It's irrelevant to put exculpatory information in your report. And I don't like the way Anderson phrased that question. He didn't phrase it correctly. He said he should have said you didn't think it was important to put in your report that a CRPS specialist told you that CRPS is often mistaken for Munchausen. You didn't think that was important? That's exculpatory evidence.
Because That's the whole point of the evaluation and gathering all the records. The problem in these cases is
that's not all the records, though. You're leaving out what he told you.
That the treating physicians have not done that. And so the fact that he, who sent her to Mexico for the ketamine coma, told me not to investigate child abuse, it was completely irrelevant to me because my job was to investigate child abuse. So if I had come away from my job saying, I was supposed to do this, but this doctor told me not to, so I'm not doing it.
My job is to investigate child abuse. Do you see what she's actually saying is my job is to prove that you're a child abuser. Her job is not to investigate the child abuse because she will not look at the other side of the story. All she does is build a case against you, and she's about to admit it's your job to prove her wrong. In other words, you're guilty until you prove your own innocence, and she will not put one thing that's exculpatory in her file.
And there's no evidence of anything here.
Let's go back.
Was to investigate child abuse. It's irrelevant to me because my job was to investigate child abuse. So if I had come away from my job saying, I was supposed to do this, but this doctor told me not to, so I'm not doing it, and there's no evidence of anything here, I would not have been doing my job even remotely near a standard of care.
Do you not understand the importance of putting both sides of the story in your report?
The both sides of the story is the responsibility of the various people who are going to present it to the court. My job as the medical director for the child protection team is to do what I need to do
for the state. My job is to make the case for the state. It's your lawyer's job to make your case. It's not my job. It's not my job to add. And actually, but she's wrong. And this is where he needed Sean McMillan, because he doesn't come at her with, wait a minute, are you telling me that in your training, there isn't something in your training that says you must, when you are representing facts to a court, that you must make a complete record? And you know that what it means to tell the truth and nothing but the truth, that also means we don't omit things. That means we don't omit things, right? And if you omit something from a report that could be exculpatory to the defendant, you have lied. You have committed perjury. That is your job is to be honest and truthful with the court. And when you leave stuff out, that's not honest and truthful, is it? I wish he had said that.
To assist the investigation of the various people who are going to present it to the court. My job as the medical director for the child protection team is to do what I need to do to assist the investigators and the detectives and the attorneys that are involved in the case as to whether there is evidence to support a diagnosis of whatever type of child abuse is being assessed. So it's not my responsibility to lay out some whole long argument about what it might be otherwise if I have extensive evidence to support that it's a type of child abuse.
What? It's not? It is not your job to lay out alternative possibilities. You think if you have evidence that it is child abuse, that excuses you from putting any exculpatory information in your report? The fuck? No, it doesn't. Sean McMillan would go nuts right now. I got to show him this. I have to clip it for him. He's so busy that he can't watch this trial. He would go crazy if he heard this. He would destroy this woman. And I'm really annoyed at Anderson. I mean, I don't think he did his enough research on this, although it doesn't matter. It's not in front of the jury. This is for an appellate thing anyway. So the jury's not going to hear this, but damn.
Dr. Smith, you know there wasn't a single child psychologist or child psychiatrist that diagnosed what you were claiming. You're aware of that, right?
That's also irrelevant.
So you are
It is?
the ultimate.
It's irrelevant that there isn't one psychologist who agreed with you that Beata has Munchausen syndrome by proxy. That's irrelevant. It's irrelevant. You heard her, folks. You heard her. It's irrelevant that specialists disagree with me. I'm the child abuse doctor for the county, and anything I say the judge believes, and I can rip little children out of their beds in the middle of the night, send the cops there to drag your child away simply because I say so. Me and me alone. I'm the god of Pinellas County when it comes to child abuse.
Decider of. So you are the ultimate decider of medical issues which you have minimal or no training in.
I have extensive training.
Yes, but
In-
you're not.
That's a Proffer. You can answer, Dr. Smith.
I have extensive training in evaluating child abuse and neglect. Medical child abuse is a child abuse pediatric diagnosis. There is a parallel track in psychiatry where there's a thing called factitious disorder imposed on another, which is assessing the perpetrator or the caretaker in that scenario. But I don't need a psychiatric degree to assess medical child abuse. I'm very well trained to evaluate medical child abuse based on my child abuse pediatrics experience and board certification.
Well, there's not a single child psychologist or psychiatrist that agreed with you. You do realize that, don't you?
No, I don't.
Well, name a child psychologist or psychiatrist that examined Maya Kowalski who agreed with you.
Well, that wasn't their job to write in the report whether there's medical child abuse. So that specific thing documented by, for example, Dr. Cabot or Dr. Katzenstein, I don't know. Honestly, I'd have to look back to see if they ever documented that as one of their diagnoses. But that's not their job. My job is to assess that, and if I present adequate evidence to the court can act on that. The court has every
here's
ability.
What she's leaving out. Here's what she's leaving out. The court has every ability to look at all the evidence. They don't. It is not. This is the way the state. Please believe me when I tell you that the state will railroad you every time. He will railroad you every time. The state will. The state agents will. I can't even talk right now. I'm getting a pounding headache. I'm getting a pounding, splitting headache right behind my right eye. Let me see if I can calm down for a second. I'm sorry. This is literally making my head explode. I have to go back and listen to that again.
While I breathe. Assess that is one of their diagnoses. I don't know. Honestly, I'd have to look back to see if they ever documented that as one of Dr. Capital child abuse.
Psychiatrist that examined Maya.
No, I don't.
Well, name a child psychologist or psychiatrist that examined Maya Kowalski who agreed with you.
Well, that wasn't their job to write in the report whether there's medical child abuse. So that specific thing documented by, for example, Dr. Cabot or Dr. Katzenstein, I don't know. Honestly, I'd have to look back to see if they ever documented that as one of their diagnoses. But that's not their job. My job is to assess that, and if I present adequate evidence to the court can act on that. The court has every ability to pull all these people in, including Dr. Kirkpatrick, including Dr. Hanna. I think they testified in the dependency action. And if the judge decides that there's serious question about whether I'm right, then the court makes that decision based on.
Folks, the court that she is talking about. Let me see if I can get this out, because I feel rage boiling up inside of me. The court that she is speaking of, the dependency court, is not real. It's not a real court with real standards of evidence. It's one judge and no jury. Most of these judges, and let me quote from the great Judge Judy Scheinlin. Judge Judy said that family court is full. I'm going to need to look this quote up because it's so good. I have to get it right. Judge Judy, family court. It's so good. A dumping ground for morons and political hacks that should be monitored by the press. It is a dumping ground. All right, I have to embiggen. hold on a moment. It is family court is a dumping ground for morons and political hacks. And she was speaking of the judges, specifically the judges. Many of them, I don't think you understand. Many of the judges in family court, they're the lowest judges in the country. Okay, they're lowest on the totem pole. It's the job nobody wants. Nobody wants. Nobody wants to be a family court judge. In fact, other judges and lawyers even look at you like scum. You're scum. Like, it's like being, it's just lowest guy on the totem pole, okay? It's where people start and then you move up. You hopefully move up. Traffic court is a step above family court, if that tells you anything. So when Sally Smith says, well, the judge has every right to look at the evidence then and decide which one of us is telling the truth. The reason why Judge Judy called it a dumping ground for morons and political hacks, in family court are appointed or elected, but these elections are won by 2-3 votes. So whoever pays the most, a lot of times you don't even have to have a law degree. It depends on what state you're in. You don't even need a law degree. It's like being on a school board. It's like a person who wants the title judge, but they don't want to do much to earn it. They don't want to spend. Okay. Think about an appellate level judge, and you've got family court judge way down here. Okay, everybody wants to get up to that appellate level or criminal court. Like state criminal court. People respect those judges for the most part. Family court it's like equal or lower than traffic court. Are you all just learning for the first time that you don't have to have a law degree to be a judge in this country? Look it up. Not all judgeships are the same, and it's family court where you're going to find this the most. That's why she called it a dumping ground for morons and political hacks. The political hack part is about getting appointed by your friends. I don't even have a glass. At this point, I don't even care. This makes me so angry. Morons and political hacks. T-Rex. Megan is mad when she's not even yelling. She's just talking kind of calmly. I'm trying very hard. I'm trying very hard to keep it in, because I don't want to scream and blow out your eardrums. Judge Judy, by the way, was a family court judge, and the way that Judge Judy's show got started was that she invited, for the first time ever in New York, she invited the media in because she believed that what she was doing in family court was really important. In fact, let's take a look at her. Let's watch her talk about it. I have it right here. I wrote this article in December 17th, 2019. Let's look at it, shall we? Mike Middleton says Megan's at the point where she's not even mad anymore. She's just totally and thoroughly disappointed. Yes. Wait, I can't. The louder I get, the more my head pounds. I'm trying to keep it quiet because as soon as my blood pressure, I think, is spiking. And so I need to just calm down because I'm getting very angry inside. Look at that freeze frame. It's a great freeze frame. So Judge Judy went on Norm. Oh, God rest both of these people, right? Didn't Judge Judy pass away recently? I hope that that's true.
And I really felt that the family court was a place that should be open to the press.
Yes.
Because at that time in New York, and probably in a lot of other places, it was sort of the dumping ground for morons and political hacks. People who had gone around and collected signatures for politicians to get on the ballot. They say, we owe them a favor.
Yeah.
And where are we going to put them? We can't put them in the civil court or the Supreme Court because press goes in there to report. So we have to put them in a place where nobody can see the morons that we're pointing to the court. Now, I know that because I worked in the family court as a lawyer. And it was frightening to see the mentality of people who were impacting on the lives of families and children.
The judges.
The judges. So I thought it was a great idea to have cameras in the courtroom when I became a family court judge. And
when you were a lawyer in front of these judges that you call morons, did you ever find yourself in contempt of court for such talk?
I never called them a moron to their face. I did incur the wrath of several who tried to keep me off the bench.
You were a prosecuting attorney.
I was a prosecutor. I was a prosecutor. Yeah, I didn't believe in excuses.
Yeah.
So when I had the opportunity to say to 60 Minutes, yes, you can come, or no, you can't, I said, if I allow cameras in my courtroom, perhaps that will open up the family courts so that people will be able to see what kind of justice is being delivered
What a wonderful
by this
woman.
very expensive court system. I actually believe that in order to be a family court judge where you touch so many different issues involving family, you should have a family.
That's very interesting.
And because if you don't have a family, you have a son?
Yes. Wait, how'd you know that?
I do my due diligence just as you do yours.
Yeah. A certain empathy comes immediately upon
right.
children.
You know what teenagers are like. You know when they lie. You know when they try to get over. You know the excuses that they make. You're divorced, right? So you know what that is like. I've been divorced.
Okay, so no one can explain it as well as she can. I mean, if you know, she knows what she's talking about. Okay. She practiced in family court for many years. And I'm so glad, by the way, Judge Judy is still alive. She's 81 years old. Thank you, chat. And God bless you, Judge Judy. It is a dream of mine to interview Judge Judy someday. I would love to talk with her, and I hope she lives another 50 years. This woman she's a national treasure, and I would love to talk to her more about family court. I would love to hear more in depth about what she's witnessed, because what I've witnessed, I feel that what she said to the bottom of my soul, because I have witnessed it too. And it makes me profoundly sad that this is something that people don't know. It's been a secret underneath in closed courts. What she said is totally true. They put the morons and the political hacks where there are no cameras. And I've been saying for years that we need cameras in family court. It would solve this problem tomorrow. Put cameras, I want body cameras on these judges. I want body cameras on them, because here's what they're doing. Let me tell you what they're doing. Let me tell you what Sally Smith just told you that they're doing. She just told you that they're doing this. She gives them a report that leaves out all the exculpatory information. She doesn't tell you what Dr. Kirkpatrick said. She doesn't tell the judge that this CRPS can often be confused with Munchausen syndrome by proxy. She doesn't tell you that. She leaves it out of the report. The judge, because he's a lazy piece of shit who probably didn't even go to law school, or he's a political appointee who graduated last in his law school class and couldn't get any other job than family court, doesn't do his due diligence, doesn't look at the evidence presented to him, doesn't even let the parents speak on their own behalf. Cynthia Absug was told she wasn't allowed to speak to the judge. Her first hearing she went to, she never saw the evidence against her. She wasn't told she had a right to a lawyer. And then when she got there and was given the thing 10 minutes before the trial, 10 minutes she had to read over the thing, she was told by the judge he didn't want to hear from her. He had everything he needed. Or she, I remember it was a woman. I think it was a woman. Had everything she needed to make her ruling in the case. And she had sheriffs leave that courtroom and go confiscate her son, her 7-year-old, on the word of a lying ass guardian ad litem who had already been charged with child abuse, just like this one in this case, not the guardian ad litem, but Kathy Beatty, the social worker. She never let Cynthia speak on her own behalf. She asked her one question. She said, "Did you tell people that your son is terminal?" And Cynthia said, "What? No." And that was it. She sent the sheriff to go get her son. She didn't allow her to speak on her own behalf. There was no jury there. There was no member of the press there. There was nobody there to say, "Hey, it seems like this woman may have had her due process violated. It seems like perhaps this wasn't a fair hearing." I am outraged and incensed at these motherfuckers. I'm just going to say it. I'm going to quote Nikki Rackets. "These motherfuckers lord over us like a new aristocracy." And where do they get the goddamn permission to do it? Nobody is questioning Sally Smith's report. She's putting only the things that she wants in the report. And the judge, who's a political hack or a moron, you heard it from Judge Judy, and we believe what she has to say, looks at Sally Smith's report and grants whatever she wants. She wanted to say Nick, but realized there's more than one Nick now. It's true. Nikki Rackets. It's true, though. This country is in grave danger. I don't want to get too dramatic, but this is the time to tell you, you're in grave danger. I've been warning people from my small little website for 20 years that you're in grave danger. Your rights are in grave danger because of people like Sally Smith. Brian, I can't calm down. You don't understand. You guys are all worried about an election in 2024 and who's going to be the president of the United States, and it doesn't matter. And let me tell you why it doesn't matter. Neither one of these political parties gives a shit about you or your rights. They are there to make money. That's why they're there. Our entire system has been turned on its head. It is upside down. Your rights are gone. You actually never even saw it coming. You didn't even know it happened because they empowered little lordlings like her to have unbelievable power over your life. And you never got to vote on it. You didn't get a say in it. And you only find out. You only find out when it's too late and they're dragging your child away from you. And I'm trying to tell you, wake up. Wake up. Take it back. We are either a country that is for the people, of the people, and by the people, or we are living under tyranny. And I'm telling you, this family found out the hard way that their rights are gone. Their rights don't exist. Yours don't either. You just don't know it yet. They're gone. And it's the family court system that did this. It is the institutions like the FBI and these investigatory agencies that have empowered people like Sally Smith to come in without a warrant, to search through your private medical records without a warrant. That's a Fourth Amendment violation. She should be handcuffed. She should be taken in front of a tribunal. She should be tried. And then, when found guilty of violating your constitutional rights, she should be executed. And I don't mean that in a way that everyone's going to be like, "Oh, she said she's threatening this woman." No, our system of government is totally screwed up. Our system of government should protect the people and not the state. The state should face the ultimate consequence for violating your constitutional rights. And I think that should include the death penalty after a fair trial. I do. And I hate the death penalty. I actually think nobody should get it except government officials who violate your civil rights and people who hurt kids. Everybody else can have life in prison, but I think it should be on the table for those other people. Because how else are they going to ever understand that violating civil rights is a serious, like it's a serious offense? You know, these people violate your civil rights like they're getting coffee at Dunkin' Donuts. Well, it's my job. I know, Kirby-side. I may have to rethink it. You just literally railed that there are no fair trials. It's true. I did. So because of that, we have to get rid of the death penalty. This is what I struggle with. I've talked to Steve Gosney about it so many times. Because the court system is so screwed up. And we saw it with the Zachary Anderson trial, right? No body, no evidence, nothing on the cameras, like didn't see his van going from here to there. No evidence that Zachary Anderson murdered that man. None, no evidence. And yet he's going to prison for life. So, right. We can't, there are no fair, are there fair trials? Yes, sometimes no. Sometimes yes, sometimes no. So this is why I go back and forth on death penalty. Totally. I think maybe just get rid of the whole thing. But then I see cases like this, and I think that government officials should be held accountable to the ultimate consequence of the law. I mean, if I'm held accountable, if I can face the death penalty for breaking any numerous types of laws, how come they cannot be held to that standard when they violate our most basic human rights? We're talking about human rights here. So it's something I struggle with. It is. It's something I struggle with. Because again, our court system is an arm of the state. The judge is the way I look at it now, it's like the judge works for the state. He gets paid by the state. How can he be objective in the face of the state versus you, the public? He can't. He lunches with the state. He goes to golf with the prosecutor. He's in the same club as these people. They're all the family court judges. The other reason why family court is so goddamn unfair is because these people work with each other every day. They're coworkers. And I know that lawyers disagree with me on this. LawTube will disagree with me all day long. They'll be like, well, it's just like any other job. And, we do put on our face when we go to court and we pretend to be enemies for a while, but they're really not. They're coworkers. Defense attorneys, not so much. They're on the outs, But the prosecutors, they're holding fundraisers for the judges. They're raising money for the judges for their next election campaigns. It's disgusting. That is allowed when you go and you argue in front of a judge, but you're allowed to donate to his campaign. It's disgusting. Okay, I think I'm done with that now. I think we can go back to the how long did I just rant for like an hour? What happened? I think I just woke up from a fugue state and I am unsure what just happened. This is my life though, you guys. I've done this. I've covered these stories for 20 years and I just can't.
On the evidence that they received. That's not my job to litigate the whole thing and put out all of the potential possibilities in the case and say, I'm the child abuse pediatrician, but I don't really know if there was child abuse here, because in this case, there clearly, in my opinion, was child abuse here.
Yeah. So you did not put in any of the conclusions or any of the data from Eagle's Wings and those therapists and psychologists that saw the Kowalskis, did you?
There was a licensed clinical social work intern who saw Maya and her family at Eagle's Wings. And I don't honestly know where that was in the pile of records when I was writing up my report. I kept writing part of the report, having to do other things, writing part of the report, having to do other things. And I inadvertently did not include that in my report.
Well, you did research it enough to realize that Rebecca Johnson had a master's degree and over 20 years of experience as a therapist at Eagle's Wings. Did you not?
Well,
wait. Glenn Croy, thanks for the super chat, says, yes, let the rackets flow through you. That's what happened. I started quoting rackets, and then it just all went from there. Am I banned off of YouTube yet? I don't know. I might be later. Make sure you're following me on Rumble after that rant, because it might be a necessity now. It might be a necessity now that you know where I am on Rumble. So in fact, before we move any further, in case I have just incriminated myself in some way, I don't know. I know that we're not allowed to have a lot of opinions here, and my opinion on, government workers and the death penalty might be one of them. I don't know. But I just want to reiterate that I meant in a lawful way. I do not support any unlawful action against anyone in the state. Never. I would never say that. Mandalore Wise 01 says, Megan going full judge as karate mode right now. Oh, all right. Let's see. This is true. McCrae says, I didn't mention the Alphabet Mafia, so I'm probably safe. Probably safe. Linda's the start of a Megan Fox bail fund. Yeah, maybe. But in this day and age, this is the thing. The state has grown so all powerful that you have to be worried about what your thoughts, like what you think, which is insane. It's insane. And they know. No fly list. Thomas, here's the good news. I don't want to be on a fly list. I don't want to be on a flight. Did you see the collision that happened because of a air traffic controller mistake? Yeah. So people are going to die soon on airplanes because the Air Traffic Control Federation, or whoever the hell it is that does air traffic control, well, they're interested in diversity, equity, inclusion now. So they have hired a bunch of people who don't know shit from Shinola, and now planes are colliding. So that's awesome. And I hope I'm not on a fly list because I don't want to get on a plane. No, thank you. No, thank you. Oh, I've had about as much inclusion and diversity as I can take, and I don't think it belongs on planes. So I'm just going to drive to wherever I need to go. All right. I'm going to try and get back to this now. I feel like I've derailed the entire stream.
Well, the question really, in terms of my part, is whether
if you knew that or not, man.
I knew I'd have to look and see exactly what her credentials were. I'd certainly, defer to you if you're reading her credentials off. But it's irrelevant unless she did the whole thing I did, looking at all these medical records and has expertise in medical child abuse, for her to be able to say one way or the other if there was child abuse or not.
Okay. Look, did anybody agree with your assessment that there was no CRPS?
Anderson. Okay.
Yes,
all right.
I believe they did.
Who?
I believe that there were multiple people on the hospitalist team that didn't think she had it. And I believe that although there was probably some question about whether she might have some sort of amplified pain disorder, the pain management team didn't think she had CRPS.
Well, amazingly enough, we did have Dr. Elliott in here to testify, and he never said that she did not have it. None of the doctors so far testified, A, that they were experts in CRPS, or B, that she did not have it. Are you aware of that?
No, I'm not. I wasn't supposed to watch any of the testimonies. I have no idea what people talk
Gather
about.
that from your investigation, though. At the time, did it come to your attention? Nowhere in any of the records did anyone who had any expertise in this, that is a pain management doctor, a neurologist, or a anesthesiologist, ever agree with your assessment that there was no CRPS?
I think I just answered that. Yes, I believe there were people that had the same opinion.
Who?
Okay. What did you check with Dr. Spiegel, a board certified neurologist that treated Maya and confirmed CRPS?
Objection assumes facts not in evidence.
What?
Any answer?
How can that assume? What a stupid objection. Objection assumes facts not in evidence. The question was, did you speak with this doctor? There was no fact.
Dr. Spiegel had this 10-year-old child do hyperbaric oxygen treatment, I believe, on 40 occasions in a row when she also.
So what? It's oxygen, lady.
Also got ketamine on some of the same days. So I wasn't terribly worried about whether he thought or did not think that she had CRPS.
Because you'd already decided in your mind that a board certified pediatrician with his years of experience was not qualified to render an opinion on that. Is that right?
Objection misrepresents the credentials, and I asked a comment on another Crumbill note. Go ahead and answer.
I'm sorry.
Dr. Barr,
yeah,
a board certified neurologist, he testified and confirmed CRPS. Did you put that in your report?
I don't know that I specifically said that he said that diagnosis. I think, as I recall, without going into the stack, that I did say in the history that Dr. Kirkpatrick had diagnosed her with that. Those people might have had that opinion. I don't think, based on my review of the CRPS literature and discussions with physicians since then, and in the context of all the evidence that there was of medical child abuse, that Dr. Barr's opinion, if that was his, that she had CRPS, was reliable.
Okay, so now Dr. Spiegel is not reliable, and he's a neurologist. At least will you agree that neurology and anesthesiology are the two areas that are most involved in the investigation of complex regional pain syndrome?
I imagine those are people that typically evaluate and treat patients with complex regional pain syndrome, sure. But not all neurologists and pain management or not all neurologists or anesthesiologists are, if you will, created equally.
And how
There
are you the judge?
some who practice at a very high level, and
who elected you to decide who that is?
having reviewed medical records from all kinds of providers all over the state and even other parts of the country for 35 years, read through information and see all the supporting information that they have and compare that with other information that I gather in my medical record review, I can assess whether the person that made thousands of dollars was reliable or not. And I didn't find those people to be particularly reliable in terms of their diagnosis, even though I certainly included their information in my report.
Dr. Hanna, a anesthesiologist with over 25 years of experience in treating CRPS, you didn't put his confirmation, or excuse me, he did a diagnosis of CRPS in your report either, did you?
I believe in the history I made reference to that. I'm pretty sure I did say that he, made that diagnosis. But this is a doctor who was giving a child, a 10-year-old child who was on the small side, 1,000 milligrams of ketamine, anywhere between 8 and 32 milligrams of Versed, doses of Zofran, 1,750 milligrams typically of magnesium, all at the same time in an outpatient setting with no documentation of vital signs. And there was indication in the records that appeared to me to suggest that the family member was the person monitoring the pulse oximeter.
She's a
so
nurse.
That person, to me, is not.
She's qualified to monitor a pulsometer. She's qualified. Oh my God, I can't even with this woman. I can't. Manders gifted 5 memberships to the Fox Den. Thank you so much. I appreciate that. Nick Campbell says, excuse me, I'm not going anywhere for my memes. I'm earning brownie points with TC Jesus. Thank you. Trash can Jesus. Kelly says, you won't go to jail. Just all you meme makers on locals will. LOL. Oh, and again, if you think that you have rights in this country, a dude just went to prison for 7 months for making a meme. A meme. A meme. A meme. Yep. Might be time for more whiskey.
Particularly reliable in terms of whether this child needed the treatment that she was getting, whether he made an accurate diagnosis or not.
No, this is not in front of the jury. This is proffered testimony for an appeal. This did not get shown to the jury, unfortunately. And I think that when they get off of this trial and they are allowed to look at, the news coverage, I think this clip is going to shock and dismay them. I think they're going to see it, obviously, at some point after the trial is over when they look it up. And I think it's going to shock and dismay them. And I hope that they have made the right decision so that they're not so that they don't fall down on their knees and cry. I really do, because if they allow the hospital to get away with this, and then they go and they watch this testimony and they see this woman who presented herself in a totally different way in this proffered testimony than she did in front of them, I think they're going to be extremely disappointed if they decided the hospital was not liable for what they did to this family.
So I put his information in my report. Yes, I discounted his diagnosis.
And of course, you discounted Dr. Cantu's confirmation of CRPS.
Doctor number 5.
Well, I never got any records from Dr. Cantu, so I couldn't really address that whole
But I'm sure I would have discounted it.
Situation other than from the WordPress blog. This person put a 9-year-old child in a ketamine coma for days. It took her probably about a week to just be able to be discharged from the hospital after that.
And she's fine.
So
I didn't find him reliable from what I saw.
all right. So if I'm understanding you,
according to defense testimony, she suffered no harm from the ketamine coma.
the fact that 3 different treating anesthesiologists specializing in CRPS, 2 different neurologists specializing in the treating of CRPS, you know more. Fair?
I don't know more. As I said, I looked at their information, and based on what was done with this particular child, I did not find their opinion to be reliable.
And who elected you to be the judge of whether all of these board certified physicians were reliable?
Nobody. I presented it to a real judge who made a determination.
Well,
a real judge?
Isn't it true?
A real judge. She just called a moron or a political hack a real judge. And I actually think that in Judge Carroll's mind right now, if he was really listening, I wish we could have seen his face when she called the family court judge a real judge. I think it would have been really funny I hope he was able to keep his face straight, but maybe he wasn't. I think he probably snickered. Any practicing attorney in that courtroom also should have snickered at that. A real judge, a real judge. You mean the morons and the political hacks who get appointed to the bench for a political favor, and then they have no cameras there, so a bunch of them don't have law degrees, and they just like fuck up people's lives all day long. Those people, that guy, that's a real judge. I'll tell you what, Judge Carroll's a real judge. He's a real judge. Regardless of the outcome of this case, Judge Carroll is a real judge. Oh shit, it's happened. It's happened. We have frozen. Your host is going to be gone for 3 minutes. I need to check. Oh, crap. Oh, I hope I can find the space that I'm in. Okay, I got to reset my computer, you guys. I got to reboot. Hold on. I'll be back in 3 minutes. Entertain yourselves. You know the drill. Do some squats. I'll see you in a minute. All right. Oh, shoot. The camera colors are all off. That's not what we want. I have to redo the camera. Hold on. The white balance is on, and that's screwing everything up. There we go. That's better. All right. All right. Your call is very important to us. Please stay on the line for the next available agent. I am so proud of you. Look at all of you who stayed. You all stayed. Incredible. Thank you so much. All right. Let's see. What were we doing? Why is StreamYard behaving this way? Oh, guys, you guys, I can't even with StreamYard lately. I don't know if it's my computer or if it's StreamYard anymore. I don't know. I don't know. All right. I couldn't be, my computer was frozen. So I actually couldn't see what timestamp we were at, but I believe it was right around here. So let's see if I'm right.
That I did say in the history that Dr. Kirkpatrick had diagnosed her with that.
All right, we're still talking about Kirkpatrick, so it was beyond that.
Nonsense.
Because an investigator would.
I love this part.
He was on the
Okay.
small side, 1,000 milligrams.
All right, it was right here.
Not all neurologists or anesthesiologists are.
Yeah, a little bit further.
Of CRPS in your report either, did you? His confirmation, or excuse me, he did a diagnosis of CRPS in your report either, did you?
I believe in the history. I made reference to that. Yeah, I'm pretty sure I did say that he, made that diagnosis. But this is a doctor who was giving a child, a 10-year-old child who was on the small side, 1,000 milligrams of ketamine, anywhere between 8 and 32 milligrams of Versed, doses of Zofran, 1,750 milligrams typically of magnesium.
You gave her Haldol. You gave a neurotoxin. You gave a neurotoxin to a child. You gave a neurotoxin that can cause brain damage to a kid.
Magnesium, all at the same time in an outpatient setting.
Oh no, she got magnesium, you guys. Oh no.
No documentation of vital signs, and there was indication in the records that appeared to me to suggest that the family member was the person monitoring the pulse oximeter. So that person, to me, is not particularly reliable in terms of whether this child needed the treatment that she was getting, whether he had made an accurate diagnosis or not. So I put his information in my report. Yes, I discounted his diagnosis.
And of course, you discounted Dr. Cantu's confirmation of CRPS.
Well, I never got any records from Dr. Cantu.
All right, so we heard this.
For that.
So if I'm understanding you, the fact that 3 different treating anesthesiologists specializing in CRPS, 2 different neurologists specializing in the treating of CRPS, you know more. Fair?
I don't know more. As I said, I looked at their information, and based on what was done with this particular child, I did not find their opinion to be reliable.
And who elected you to be the judge of whether all of these board certified physicians were reliable?
Nobody. I presented it to a real judge who made a determination.
Well, isn't it true, ma'am, that you are not a medical investigator? You are, in fact, a medical prosecutor.
Yes.
That's absolute nonsense.
Because an investigator would include both sides of the story and let the judge decide, right?
No. The Child Protection Team medical director will assess whether there's medical evidence to support a diagnosis of child abuse, and then the dependency attorney will present that to the judge. And the other side gets attorneys also. There were 5 in this case.
So we have no obligation to present exculpatory evidence to the court. And she did it in criminal court too, and that's against federal law. It's the Brady law. And she did it in criminal court too. Now, in dependency court, she's kind of right, although her training says otherwise. But in the dependency court, it's not like anybody's going to check. Who's going to check? The moron or the political hack behind the bench? Nah, he's not going to check.
And they present all the information, and then the judge tries to decide.
No, you were supposed to present all the information. You are the DCF child abuse doctor. You are supposed to give all the information. Sean McMillan would be losing his mind right now. I'm telling you, Sean, you got to see this.
You know whose information is more reliable.
Here under oath, are you telling us, are you an investigator or are you a prosecutor
I am
of
neither.
the information?
I'm a medical doctor who is an expert in child abuse pediatrics.
Mr. Anderson,
I
I'm
got
getting
it.
very wide latitude.
I'm done.
You're finished? Okay. Mr. Hunter, anything further in proffer?
Very briefly, Ron. When you spoke with Dr. Kirkpatrick and he warned you off, did he tell you that he had last seen this child 10 months before the conversation?
I honestly don't recall if I already knew that. I might have already known that.
And when you wrote your report, you had the Tampa General Hospital records, the Lurie Children's Hospital records, the All Children's records predating October of 2016.
All right, you know what, Hunter? I don't give a shit.
All those hospitalizations,
I
with all
don't
those
care what you have to say anymore. I'm done with you. So she's done. They release her from subpoena. She is not coming back. Let us see what happened after that.
There's Mr. Altenburn. Let's talk about the dependency court order instruction. I've now had a chance to review Mr. Anderson's proposed edits. I didn't know if Mr. Elliott or Mr. Anderson wanted to say anything on them.
Briefly, I would defer to Mr. Anderson on the details. It was a continued attempt to make these a little less mind-numbing, simplify them down to something more important, make sure they had a little more balance.
Your Honor,
What I did was go back, review the prior order the court had drafted, and compare the orders themselves, and then reviewed as much of the notes as I possibly could on what transpired then as testified to now. And the goal was to try to reduce down to the bare essence those portions of the orders that were pertinent to what the jury is being asked to do here. The idea being that the simpler the orders are, this order is, and the simpler the quote rules are, the less questions we're going to get. This is a very intelligent jury that asks a ton of questions. My concern was that if we give them too much or virtually anything that isn't explained and suited to what they're doing, we're just going to have we're going to spend a lot of time answering questions when we really need to be concluding the case. So the idea here, going through the October 14th order, and this is not perfect by any means, obviously. I'll say there's.
Wait, are we just doing jury instructions for the rest of today? Is that what's happening here? Did the jury get excused and go home? Because if that's the case, I'm not covering this now. I don't want to watch jury instructions today. That's like all I can take. No, there's a witness coming. Okay, but if they're going to talk jury instructions, like I can't right now. I know they're important. I know that jury instructions are important, but if you guys want to watch jury instructions, you can go and watch that back later. I don't. I want to get on to the witnesses. I should listen. Oh, now you're going to try and talk me into it. I think I should skip it. That's what I think. I think Jingleberry's right. I know there's more testimony. I want to get to that. It was crazy. Oh, shit. All right, we'll speed it up.
Word or two left out here. But the goal was at the beginning and the end to put in a caveat that that the court has, without going into great detail, but that the court has determined the following causes of action are not subject to the immunity. And I think that probably the top of the page on page 2 there needs to be a little stronger than what I've got. And then you'll note at the very end, page 8 of 8, I've got that the same warning. So I wanted to begin and end with the warning, the first one being pretty basic, and the second one being more in line with what I thought counsel, what had been agreed to with everyone. And then we go through the October 14th order as to the people involved, the November 10th order as to the people involved. There in the November 10th order, if you look at page 5 of 8 under other relevant requirements in the bottom, it says that the November 10 order allowed Maya Kowalski to have religious artifacts. A sentence that I did not put in there, but I think should be put in there, are words to the effect, but there was no prohibition on her having religious artifacts before this order. The reason being that by simply stating there's an order, in the perception now allowing religious artifacts, the jury might get the idea that prior to this, they were prohibited.
somehow. And so there had to be a court order for her to have them. And that
Oh,
wasn't
they
the
were
situation.
never
She was allowed to have
prohibited.
them under their patient's rights. And the order was really clarifying some problems that had arisen. Then on page 6 of 8, I thought I deleted this. Apparently I didn't. The December 9, 2016 order, as I read it, really does not affect anything that we're talking about here because it has to do with a birthday and who gets to go to the birthday. And again, things like that, while technically if we're going to be complete with all the orders, it goes in it. Still, I believe that the less things like that are in this, and the more we focus the jurors onto the specifics of the orders that, for lack of a better term, count, the more efficient this will be. On the December 16th order, I have been wondering about the statement about the dependency court allowing Johns Hopkins to supervise the video calls. His medical staff could suspend those calls only insofar as, again, I don't know, in my review of the original order, it did not have the language attendant to that sentence and that portion of the order. But clearly, based on the other orders, Johns Hopkins was always subject to its own internal rules and regulations. My concern here is that the jury has heard a lot about the patient's rights, a statement of rights incorporated into the same packet that has the release the defense wants to argue in favor of. And it clearly was part of the agreement between the parties and part of their website and part of this case. And so I wanted to be able to include in this something to the effect of according to its rules and regulations, so on and so forth. So that change would go right before this was a change from the November 10 order. I have not put it in yet, but I think it would be appropriate to do that. Although, again, it wasn't specific to this part of the order, but specific to virtually every other part of the orders. Every other order, when they defer to Johns Hopkins, it again ties it back into, and by the way, you have to follow your own rules and rights that you've given. And then we go through to the December 27th order on page 7, and we go through the specifics of that. Again, I tried to track in readable, because some of the orders, I think everyone will agree, are difficult to navigate for us, and because there are inherent inconsistencies, and for the jury to do that by just putting the data out there, which may be, from appellate purposes, the cleanest, still, I think it is overall better, and the appellate court would understand the problems with just reciting the terms of the orders because of the inconsistencies involved and the fact that the jury's going to come back and say, well, this order says this on this time, but then on this time the order says this, and what about inside the order itself? The order says you can do it this way, but then down here it says you can't do it this way. And there are plenty of those in the orders as drafted in the shelter action. So then on the last page, you'll see again the caveat, which I put at the end after the dependency order, January 13th, discharges Maya, and that is, so it speaks for itself that none of the above orders provide them with immunity or other protection. It should be from plaintiff's claims for specific events and then false imprisonment, so on. The only other question I have in conclusion is the issue about the ketamine order. The defense has made much in the case, well, I believe will, and has to a certain extent, talked about whether or not the Maya not using ketamine after she left was some indication or admission that the plaintiffs.
I see that as a different total issue than talking about visitation. That's
not. I'll shut up about that.
Let's not mix those concepts.
Got it. Well then, I'm done. That's my explanation for the order. I'm obviously open to whatever suggestions or comments.
Your Honor, the truth is, Mr. Anderson just never wanted those orders in front of the jury from the first day of this trial. You've been trying to get them in front of the jury now for 2.5 weeks or longer. I spent more than a day trying to put together something I thought would be as concise as I could that quoted those orders. I don't know how much time you spent, but from my read of this, you rather carefully took those orders that I had provided to you and put them into simple English and was accurate about what is in them. And, all this was done. My order was submitted to you, I don't know, sometime middle of the latter part of last week. And now when we're ready to read it this morning, he wants to make a wholesale change to the whole thing. Mostly he wants to take out the sections he doesn't like and leave in the sections he does like. And so my front end on this is that I do believe that your provisions of this were an accurate transition from the orders I gave you to something that will hopefully make the jury understand it better and faster than what I had provided to you. So I don't think it needs all of these changes. I did know, by the way, that the last time we talked about these orders, we talked about, because the October 14th order was effective October 13th. I'm pretty sure the last time around we called it the October 13th order. Maybe we should say consistent on that. But the rest of this, I mean, unless you have questions about it, I think that you did a good job, and I'm content with you staying with what you wrote.
I am not going to change horses at this point in time. I believe that the proposed changes that Mr. Anderson would make this not a neutral and balanced recitation of the orders. So I'm going to stick with what I said with my change this morning, and obviously not including that one sentence that I continue to struggle with. And again, we can continue before this actually gets put into the final package that goes to the jury after all the evidence is in. We can massage the language a little bit more, but I'm not going to. Now, I will say if the parties want me to take out the birthday order and go from 5 orders to 4 orders, I don't think that changes anything, so I'm happy to take it out if you want to leave it in.
For clarification.
I'm catching up on locals chat. You guys are killing me with the memes. The Blair Witch memes are hilarious. Duncan, Idaho sent a tip on locals, $10 tip. Says, I'm about 30 minutes behind, but just want to say this particular case is being handled legally in court because the Kowalskis are civilized people with some amount of faith in the justice system. But this increasing trend of the government stepping on people's lives with no due process is going to result in some Timothy McVeigh shit and increasing violence. Yeah, I've been saying that for years. I've been saying that if we don't get a hold of this corruption, you're going to see shit you wish you never saw. And I can't, frankly, I can't believe it. We've been as peaceful. It's been as peaceful so far. But the Declaration says people are willing to suffer while these injustices are sufferable, right? We are a long-suffering people. Our Declaration says it. We're long-suffering, but when that patience runs out, it's brutal. And I don't want to see that in my lifetime, which is why I want there to be actual consequences through the law for these people. I want someone to be hit so hard by a consequence that it makes all the other jackbooted thugs quiver in their jackboots. That's what I want. I want them to fear, to be afraid of the legal consequences of their actions for once, which means they can't have immunity. They can't be immune. If we give them immunity, the abuses will escalate. Duncan, Idaho sent another tip that said, this is the sort of thing that shakes a country apart. And it's crazy how short-sighted these people in positions of power are about this. Yeah, but see, they've gone on for so long with no consequences that they don't believe there are any left. Sally Smith doesn't give a shit about what she did. She's not regretful at all. She's not regretful at all. She's perfectly fine with what she did. She's sticking by her guns and thinks she was right. I mean,
Improper orders as well. Has there been any reference that we disobeyed in any fashion?
No, that's my point. I mean, there's no allegation that.
I think that they maybe need to be added in later, depending on what they do when Kathy B's on the stand. But at this juncture, I think
It's a half of a page, so it doesn't materially change anything. So if there's the possibility that it's going to be necessary, I don't want to tell them there's 4 orders, and the next time tell them there's 5. So,
Your Honor, could we again consider adding the paragraph at the end, which just kind of balances out? There's a short statement at the beginning that doesn't affect the claims, but having that statement at the end after they've heard all this, we think would be important to put it in the right perspective.
I've already said it. I'm not going to say it again in the instruction.
So where was it in that?
All right, here's what we're going to do.
Judge,
Here's what we're going to do. I actually have to go because I need to pick up a kid from swimming. And so I cannot finish this now, but I will come back and we'll do part 2 when I'm able to. So I'm going to go do the mom stuff, going to do the dinner stuff, and then I'm going to come back and we'll pick up where we left off. So I'm sorry that I can't continue streaming, totally. I mean, I guess I could just let it go while I'm gone. You want me to just let it go and play on normal speed and then just come back? Or do you want me to start a new one? It's up to you. What do you want to do? Want me to just keep it going? But if I do that, I'm going to miss stuff. So I think what I'm going to do is we're going to end it and then I'll come back. Nick. Yeah, I'll just start a new one. All right. I got to go. I love you guys. I'll see you again soon. Today's been rough, really rough for me. And I hope this jury does the right thing because I have had enough of this. I've had enough of this injustice. It's really bothering me. And I've just had enough of it. I've had enough. All right, since we haven't done squats, that's how we're going to end the show today. I should probably not do that. Because when I do that, you guys, then a bunch of people think that the show's over. So, I better not do that. Let's end it with Thug Judge instead. I'll see you in a bit.
I understand you're moving for a mistrial when you got additional time and you can call the same witnesses to address whatever issues. Is that what you're saying?
Yes, Your Honor, because we don't. Okay.
Can we go to exhibits, please?